to mention item number 26, my lord. I pray that the matter may be taken up in the month of August
26.
26.
Inform the other side.
Yes,
On a request made by Sri B. Sharma. London Standing Council for the Railways. Matter is adjourned to be listed in the first week of August.
okay.
Have you filed affidavit?
That's why I've taken that.
By
I've sent
the-
it for vetting. my
By the same time, the affidavit in opposition is required to be filed.
May I please, my lord?
Yes.
My lord, with respect to item number 45, my lord, we
Yes.
have received our departmental instructions, my lord. 2 weeks time may be granted to file our affidavit, my lord.
45. On the request made on behalf of the respondent department, matter is adjourned to be listed after the vacation, summer vacation, to enable filing of affidavit in opposition. Yes.
Your Lordship, I'm appearing for the petitioner in this matter. Your Lordship, there is an interim order. that
Interim
will
order passed earlier to continue till the next date of listing.
be Much obliged, sir. May it please the Lordship, in item number 17, Lordship, the petitioner is died, Lordship. We are going to file the substitution today itself. Item number 17, Lordship. Petitioner is died, Lordship.
Yes.
We are going to file the substitution today itself, Lord. Matter may be adjourned.
Okay. Your N. Nirola,
Yes, Lord. I think
Miss N. Nirola, Learned Counsel for the petitioner submits that during the pendency of the writ petition, the petitioner has passed away. And as the cause of action survives, an application for substitution is being filed during the course of the day. Para? Accordingly, the matter is adjourned to be listed along with the substitution application after the vacation. Other side has been informed?
yes, Lord. I have it.
Yes.
Support to the
Yes.
problem.
May I please, Lordship, WPC 3569/25 may be listed tomorrow. If we want to withdraw the matter.
May I please, which I beg to mention item number 30 to 37. That may be adjourned.
Why are you seeking adjournment?
Lordship, some additional tech has come, Lord. So
What
we
are these
file-
matters about?
matter about Lordship?
Ex gratia.
No, Lord. It's a lot of land which was allotted to the father and grandfather of the petitioners. Lordship.
Okay, why do you need time?
Lordship, will file additional affidavit. Some
Okay, 30 to 37. In all the matters.
Lordship.
What is your name?
I am in Lordship.
Sri, I am in Learned Counsel for the petitioners in these cases, THESC, submits that additional affidavit would be filed for which he prays for an adjournment. Para? List after the vacation to enable filing of such additional affidavit.
Apply.
30 to 37, huh?
May I please, your Lordship? I beg to, with the consent of the other side, I beg to mention item number 40 and 41, your Lordship.
Yes.
In item number 40, I am for the respondent number 6, and we will file affidavit in opposition, your Lordship. And the item number 41 is a similar matter. So both the matter may kindly be taken.
Okay.
Lordship, I am for 40, 41. In 40, I am the bet.
Understood. Our request has been made. Are these matters connected?
Yes, your Lord.
A request has been made on behalf of the private respondent in WPC 1243 of 2025 for adjournment to enable filing of affidavit in opposition. The said private respondent is also the petitioner in the connected WPC 5314 of 2024, correct?
Yes.
Sarah? Accordingly, list this case after the vacation to enable for exchange of pleadings.
Your Lord, in item number 41, there is an interim.
Interim order, if any, stands extended till the next date of listing.
40.
If any, we have said one
Pleasure.
order, huh? For exchange of pleadings. Yes,
Lordship, with the concept of understood, I mention item number 25.
25.
25 on behalf of Mrs. R.T. Tito.
Yes.
Time may be required to file the affidavit. Can be taken up after.
Other side informed
Yes, sir.
on a request made on behalf of
Arti.
Ms. R. Devi, learned CGC, matter is adjourned to be listed in the last week of July to enable filing of affidavit in opposition.
Maybe Lordship. Like,
Yes,
who's concerned about other state, Lordship, I beg permission, item number 38, Lordship. You
3.
know, some personal difficulty matter may be adjourned for that.
Here for whom?
Petitioner.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed after the summer vacation. Yes.
Lordship, I had to consider item number one.
Item number
One.
1.
As I got instruction from my significant that we are not fetching this
What is your name?
and security
Hmm?
and security.
You are not on record, madam.
Yes, sir, I'm on behalf of Mr. I. Rafiq.
Ms. N. Chakraborty, learned counsel, appearing on instruction of Sri I. Rafiq, learned counsel for the petitioners, submits that there are instructions from the clients not to press this writ petition. Also heard Sri N. Das, learned state counsel, and revenue, and Ms. G. Hazarika, learned standing counsel, revenue, para. Writ petition is accordingly dismissed as not pressed. Yes.
Please, your lord. I beg to mention item number 18, my lord.
Yes.
With respect to item number 18, my lord, I have filed 2 IAs, my lord. I am an intervener, my lord. I have filed for self-impleadment, my lord. In this. So, my lord, let this matter be taken up at the second half.
When did you file?
Today, my lord.
Oh, my lord, I am for a petitioner in the case. So in any case, my lord, we are supposed to file an affidavit in reply against the affidavit in opposition of private respondent, my lord. So let it come after vacation, my lord, my prayer. In the
Okay.
meantime,
Item 18, huh?
yes, sir.
This court has been informed that 2 intervening applications have been filed today. Full stop. At the same time, Sri R. Chakraborty, learned counsel for the petitioner, has submitted that there is requirement of exchange of further pleadings. Para, in that view of the matter, list this case on 21st of July, on which date the IAs may also be listed.
Interim order may con.
Para interim order passed, tell you to continue till the next date of listing.
All right.
Right. May it please, your lordship. I beg to mention item number 25. Lordship, my learned friend for the respondent is having personal difficulty and asked me to mention on his.
25 has been mentioned.
My lord, a respondent was supposed to file affidavit if
No, it
that
has
a
been,
date may be fixed.
it has been mentioned already. What has
Multiple.
been passed?
Okay.
By friend, your RDB.
Well.
It has already been mentioned, yes.
Yeah, but I am appearing on behalf of PK Roy Chaudhary.
In item,
Item number 27.
yes.
Only attempt matter.
Why?
He instruct me that I have some personal difficulty.
On a request made on behalf of the petitioner, list after the summer vacation.
Item 2. May I please, Lordship, non-payment of Zirat Muttalite,
Jurat in what?
land acquired by your
Land has been acquired.
But-
Yes, Mr. Boru.
May it please, your lordship. Lordship, here, lordship, may kindly peruse page number 52, your
5-2.
52.
Yes.
Here, lordship, competent authority, Kala is ADC Kachar.
Yes.
He have approached before the district commissioner Kataria.
Why didn't you approach the Kala?
No, Lordship, I will approach otherwise, Lordship, but Lordship, at least his notice may go, but
No, what purpose is ADC a party here? Kala is a party here.
Kala is a party, Lord.
Respond number?
Additional district commissioner, yes, Lordship.
Yes, 5.
Kala
Okay,
is-
we'll issue notice at this stage then.
Yes.
Okay.
Moreover, there is subsection filed by the private respondent. Submit 7 and 8.
It would be a private dispute,
And
Mr. Mazumdar.
made an objection first.
Lordship, it is
Or not disposal of the.
land acquired, Lordship, they have made a objection, Lordship, but that is to be decided by the authority, whether they have any legal ground to object the payment of Lordship complete.
Heard Sri L.R. Mazumdar, learned counsel for the petitioner. Petitioners who is aggrieved by non-disbursal of the GIRAT compensation by the appropriate authority. Full stop. It has been, it is the case of the petitioner that the respondent number 7 and 8 had raised certain objections for which the disbursal has been put to a halt. Para 3 Arboro, learned counsel appearing for the NHIDCL has, however, submitted that the representation is not filed before the CALA and not filed before the appropriate authority, namely CALA. Full stop. Sri and thus Learned State Council has also raised the objection that the dispute is a private one between the petitioners and the respondent number 7 and 8. And therefore, a writ petition may not be maintainable. Para, be that as it may, let notice be issued, returnable by 6 weeks. Union of India,
I can appeal.
Sri R. Boro. Okay.
Look,
Okay. Sri B. Chakraborty, Learned CGC accepts notice on behalf of respondent number 1. Sri R. Boro, Learned Council accepts notice on behalf of respondent
1, 6, 2, and
No.
3. Both
Two,
NHIDCL and
2,
NHIDCL
3, 2, 3,
and 6.
2, 3, and 6. And thus
4 and 5.
State Council 4 and 5. Extra copies. Steps for service of notice upon the respondent number 6 and 7 and 8 be taken by State Post to TD. Steps within 2 days.
Obliged.
You file an application in the meantime before the appropriate authority. Otherwise, you will not get any. That would be the order ultimately.
My lord, matter relating to my lord, order passed without signature and all matter, in fact, is covered. That's why your lordship was pleased to fix today, my lord. My learned friend is appearing. My lord, this is the order part by coordinate.
Yes, what do you say?
What matter? What matter?
Covered.
Para 19 and 23. Page 9.
Mr. Goel, make corrections in this because this encompasses a number of writ petitions.
Mal.
Make the corrections here. We'll make the same order.
Mal.
Okay. But show it to Mr. Barua.
Mal.
Okay. A. Goel, H. Barua. H. Barua representing B. Chaudhary. B. Chaudhary is taxation, finance taxation. Disposed of.
On the last date, fix the lordship instructions were 6 for.
Yes, yes.
Doctor,
Madam, why is your date of birth certificate issued in the year 2021? The petitioner was born in 2005.
Your Lordship, 5.
What explanation? Mr. Das, have you noticed? Come to page 11. The petition number 1 claims to be 20 years of age. Petition number 2, 30, 23 or something.
1/10/2005, my.
But date of birth is 1/10/2005. Date of issue of certificate
Your Lordship,
29/6/21.
21.
Why?
Your Lordship, for the expense of, for approaching the authority for registration, Your Lordship.
Now, you are
Continue.
supposed to register your birth immediately. It's mandatory. If you do not do, there has to be some explanation. What explanation?
Your Lordship, and the next day, please, I'll take the instructions.
This
Your
is
Lordship,
important.
the reason.
No pleading to this effect.
And if second case, he was born in 2002. Come to the next page 12. What is his name? Faizur Rahman.
Your Lordship.
Date of birth is
petition-
2002. He applies in 2012.
I'll take the instruction, Your Lordship, and the next day, please, I'll be with the instruction.
The instant petition has been filed by the two petitioners with the grievance that their application for registration of their marriage under the Special Marriage Act in the Seva Setu app has not been brought to a logical conclusion. Full stop para. This court has, however, noticed that the birth certificates of both the petitioners have been issued at a much belated stage, and there is no explanation or pleadings in this regard. Para. Ms. P. Ahmed,
Your Lordship.
Learned Counsel for the petitioners, prays for and is granted 3 weeks' time to obtain instructions and file additional pleadings in this regard.
Your Lordship. Obliged.
You also obtain
Yes, sir.
take instruction. Okay.
May I please, Your Lordship, my lord, the respondents are supposed to take instruction.
Non-registration of Aadhar, I think, yes.
Well, some more time needed, my.
Why? This is a simple instruction. We passed this order on 18/6/2025. What has happened to the Aadhar?
Can it be on the last day, my?
You get the instructions, this is not done.
Look,
Registration is
step has
mandatory.
been taken, my lord, the instruction.
It's a phone call.
On Friday, my.
Send a WT.
On Friday, my.
Okay. On Friday.
Yes.
The grievance of the petitioner is with regard to non-registration of an Aadhar, which was thought to be lodged on 12/5/2025. Para. On 18/6/2025, this court had granted time to the Learned State Council to obtain instructions. Para. On the prayer of Sri N. Das Learned State Council, further time is granted and the matter is directed to be listed on Friday.
Right.
Right.
6.
Yes, matter, my lord, yes. Demarcation, without demarcation, my lord. Your lordship wanted.
Yes, SBI.
I'm. My lord will just take the judgment of the, in this matter, similar matter came up before this honorable court earlier. Now, lordship, so far the respondent before your lordship is concerned, an original application was filed by the State Bank of India before the Learned Debt Recovery Tribunal. And the Learned Debt Recovery Tribunal has given judgment in favor of the bank. Now, after that it went to the recovery officer. And the recovery officer has sold the property and sales certificate has already been.
Yes.
I'm giving your lordship the sales certificate. Now, lordship, the petitioner before your lordship, if I'm not mistaken, is Bablul Haq Mazumdar. Now, lordship, Bablul Haq Mazumdar happens to be the son of late Badrul Haq Mazumdar, who was the defendant number 3 in the original application before the Learned Debt Recovery Act. My lord has just produced the judgment of the Honorable DRT.
Yes.
Defendant number 3 happens to be Badrul Haq Mazumdar. And now the petitioner before your lordship is Bablul Haq Mazumdar. He is the son of late Badrul Haq.
Yes.
Now, defendant number 3 before your lordship, before the Learned Debt Recovery Tribunal was also the mortgager of the land, in respect of which sales certificate has been issued. And this property has been sold by and lordship in another writ petition filed by the respondent before your lordship that was dismissed.
Which respondent?
Respondent number 6 before your lordship, Siraj go down. Sirajul Haq, proprietor Siraj go down. He is the respondent number 6. He is the brother of the petitioner. He is the brother of the petitioner.
Siraj Godan is respondent number 6 here.
Here. And he filed a petition before your lordship, before this honorable court, regarding the same demarcation, all these things, which was dismissed, giving liberty to the petitioner to approach the DRT. Now, lordship, since demarcation has been done by DRT, and I have given the order of the recovery officer also, the specific receiver has been appointed for this one. If they are aggrieved, they are also the borrower. They can approach the DRT. And under section, lordship, I'll take your lordship to the Recovery of Debt and Bankruptcy Act.
Yeah, dear.
For a moment.
Recovery. Yes.
Section 30, my lord will take.
30.
30.
Yes.
Because demarcation has been done pursuant to the order of the recovery officer. And I have annexed the order of the recovery officer also, where receiver has been appointed. Now, lordship, may I read section 30? My lord has got.
Yes, yes.
Notwithstanding anything contained in section 29, any person, lordship, any person's petition also, aggrieved by an order of the recovery officer made under this act within 30 days from the date on which the copy of the order is issued, prefer an appeal to the tribunal.
Yes.
On receipt of the appeal under the subsection so and so, the tribunal may, after giving opportunity to the appellant to be heard, and after making such inquiry as it deems fit, confirm, modify, or set aside the order of the recovery officer in exercise of the powers under section so and so. So the appellate power under the order of the recovery officer is vested with the DRT. And that is the order of this honorable tribunal in the earlier petition also. So in my humble submission, lordship, so first of all, the petitioner before your lordship is also the borrower within the meaning of the Recovery of Debts and Bankruptcy Act, because he steps into the shoes of his father. His father was the defendant number 3, and upon the death of his father, he is also liable. Now, assuming for a moment, lordship, I do not know, because I have not been served with a copy of the writ petition. Assuming for a moment that there is bad in demarcation and all these things. The demarcation has been done by the circle officers, and specific receiver has been appointed by the DRT for that purpose, after the sales certificate. They are not challenging the sales certificate. Now, if they are aggrieved by the demarcation, they have to approach the DRT. My lord, under Article 226 of the Constitution, will your lordship exercise the appellate power and set aside the order of the DRT? That lordship will have to. Because specific statutory provision is there.
Mr. Chaudhary, the other day I had shown to you the latest directive of the Honorable Supreme Court that statutory attendant has to be
I've seen, madam.
invariably followed.
But yeah, whole my another friend has I think he has not gone because he has not got a copy. Whole problem is my lord, he has said, but against demarcation, no demarcation has not been done till today, my lord. It is there, my just my lord, calling is the page 30, my.
No, what is your prayer then? You come to
So
your prayer. at
my
page
question, my
19.
lord, let the demarcation be made. I am only simple prayer, my lord. Then you do whatever you like. I am not the Baba, my lord. He is my brother. My father was that person. The whole thing is the respondent number 6. He is saying, my lord. He is my brother, no doubt, my lord. Against him, there is a
No,
case.
see your interim prayer not to disturb your peaceful position.
Since-
We cannot stop the demarcation.
No, I am not saying demarcation. Let them do the demarcation.
First the maintainability will be
Just
the
page 30, my 30. Just have a look.
page 30.
30, my.
Yes, please.
It is a letter from assistant officer to the recovery officer, my.
Yes.
After finding our objection, my lord, this was your lordship.
Yes.
With reference to the above, I have the honor to inform you that as per order dated so and so in the order of proceeding by number so and so, statement and so and so.
We'll do one thing. We'll have this after the vacation. Demarcation exercise may be carried out.
Yes.
But do not disturb his position till the next date.
I'm simply.
Immediately on the reopening, you'll have
They can do by tomorrow.
he'll be-
I have nothing to
He'll
say.
be equipped with a copy of the petition. We'll we'll have it,
I
or
will start-
we'll still have it for motion even. We want to dispose this off. Entertaining,
The proceedings, my submission is that if the proceedings of the DRT hampered the fruits of the.
no, we are not stalling the proceedings. With demarcation, you carry on.
The recovery officer may carry out the.
Carry out the demarcation. Okay. Heard Sri H.R.A. Chaudhary, learned senior counsel for the petitioners, who submits that pursuant to the order dated 23/6/2025, the filing of this case has been informed to the respondent State Bank of India, Para. Sri K.K. Nandi, learned counsel, has entered appearance
For respondent number
for
1, 2, and 3.
for the respondent bank and has
They are
submitted
private respondent also.
for the respondent bank.
Respondent 1, 2, and 3.
Respondent bank 1, 2, and 3. He, apart from raising the issue of maintainability of this writ petition by drawing the attention of this court to section 30 of the Recovery of Debts and Bankruptcy Act 1993, the learned counsel has submitted that the father of the petitioner was the defendant number 3 in the original application number 6 of 2011 instituted by his client, full stop. The said OA was allowed, whereafter the property was sold by the recovery officer and sale certificate issued, correct?
Logic.
He has reiterated that since the father of the petitioner was the mortgager, the petitioner,
Who is already died, expired.
mortgager, on his expiry, the petitioner has stepped into his shoes. Full stop. He has also submitted that the present respondent number 6 had approached this court earlier by filing WPC 6609 of 2023, which however was dismissed on 6/3/2025 on withdrawal with a liberty to approach the appropriate forum. Para? Sri Nandi, the learned counsel, has however submitted that the copy of the writ petition is yet to be furnished to his client, and therefore the full instructions could not be furnished to him. Para? In view of the above, matter is adjourned to be listed on 16th of July, immediately on the reopening. 16th July.
I'll be a bit out of station
Well, tell us 18th, 21st,
after 20th.
21st of July, 21st of July, 2025. Let a copy of the petition be served upon Sri Nandi during the course of the day. Para? Till the next date fixed. Sri Chaudhary, the London Senior Counsel, prays for an interim order. Para? Balancing the equities, it is directed that while there would be no stay on the demarcation proceedings, the petitioner may not be dispossessed till the next date fixed. Full stop. The said interim order would, however, be reconsidered after obtaining of further instructions.
One thing, father was the guarantor, madam. The customer sixth is the borrower.
No, he said mortgager.
Mortgager, yes.
Six.
Mortgager.
Mortgager, he was the
Mortgager.
guarantor and
Mortgager. Mortgager.
So-
We have not said borrower.
Yes,
he was the
published.
But guarantor, borrower at same footing.
Legally, of course, but
Supreme
yeah,
Court has said.
since family matters, madam, that is.
Supreme
Anyway,
Court has said we cannot say anything else.
but-
It is up to the bank. They may even proceed against the guarantor first.
Anyway, madam, we'll. 21st or 22nd.
21st, Monday.
Item 7.
Yes, item 7, what is this?
Please, your lordship. The respondent authority has required my land measuring one quota silas for laying Barauni Guwahati gas pipeline. They have not they have not given compensation. Now it has come to my knowledge that the respondent number 6 fraudulently received the compensation amount, and respondent authority maliciously released the compensation amount which we are entitled.
No, but how do you approach a writ court? You approach the civil court.
Lordship, yes, but
And in fact, my lord, Gail has standing for my knowledge.
Who?
Mr. Mitra is usually updated.
as per rule, I am entitled compensation. They have issued notice.
Gail,
Gail,
Yes.
he is usually updated.
who Mitra,
Mr. Mitra.
as Mitra. Have you served copies upon him? Please serve copy. And we can have it tomorrow also, all motion days. Tomorrow.
Yeah.
But your maintainability will be one issue which you have to answer.
Pictures, my-
Now,
Even if your allegations are correct, can we determine?
Lordship, I have filed application before the competent authority. They refer to the district judge.
Yes,
They should refer,
yes.
but till that they do
They have not referred. Okay, get Mr. Mitra. Have you served copy upon him or not? Mr.
my lord, that's
Prabhu?
Gail, name not,
Okay.
perhaps.
There is a standing council, Sanjay Mitra. Okay. Though this writ petition has been filed primarily against the GAIL, Gas Authority of India Limited, it appears that GAIL has a standing counsel who has not been served. Para? Sri S. Burman, learned counsel for the petitioner, undertakes to serve a copy upon the standing counsel. Para? List this case for motion on Friday.
oblige.
Serve it, the name of, Para, the name of standing counsel Gail be reflected in the cause list.
Item 8.
My lord, in this case, my lord, the petitioners are the residents of my lord Parapur Sarili. My lord, for expansion of the my lord, two-lane road, my lord, towards my lord airport, my lord, for 6 lane, my lord. So my lord, respondent, my lord, authority, my lord, after properly demarcation, my issued my lord notice, my lord, on 9/7/2024, my lord. And that is my lord page 89, my lord, annex of 4, my lord. And surprisingly, my lord, they issued my lord second notice, my lord, after 5 months. Where, my lord, petitioners, my lord, land, my lord, acquired. So, my lord, interestingly, my lord, this notice, my lord, first notice, my lord, there are 7 pattators, my lord, 1 to 7. Their name has been deleted, my lord, in the, my lord, second notice. Second notice, my lord, without, my lord, proper demarcation, my lord. First notice is okay, my lord. Second notice, my lord, proper, without demarcation, my lord. They should, and now, my lord, they issued, my lord, 19/5/2025 for my complaint. We are, my lord, agreed, my lord, the second notice, my lord.
What is your grievance?
My lord, grievance, our land has been acquired.
Acquisition, can you raise any grievance for a public purpose?
We are agreed, my lord, public purpose, my lord, but as per the notice, first notice, my lord. It is 9.
No, it is the prerogative of the authority. Unless you can show it is not for public purpose or entirely vitiated by malafide, acquisition proceedings you cannot. You can get appropriate compensation. That's a different aspect. Acquisition proceedings, how do you challenge?
My lord, for a moment, my lord.
Eminent domains, it is the prerogative of the state, either for a public purpose or for a company.
My lord, without proper demarcation, my lord. That is my humble submission, my lord. My lord, 9/7 first notice is okay, my lord. Oh, proper demarcation, my lord, they have issued, my lord, notice, my lord. My lord, kindly see, my lord, for a moment, my lord, annexure page 89, my lord.
Now, what kind of relief are you expecting this court to pass? No.
My lord, to place the, my lord, entire record, my lord, for demarcation, my lord, before issuing, my lord, second notice, my lord.
We cannot stay a LA proceeding.
My lord, second notice, my lord,
We
kindly
cannot
see.
stay. We can issue notice at best. Heard, Sri S. Dihingia, learned counsel for the petitioners who are aggrieved by the aspect of issuance of a second notice of acquisition without carrying out a proper demarcation. Full stop. The said notice pertains to the expansion of the existing 3-lane LGBI Airport Road to a 6-lane road starting from Dharapur intersection.
Lord,
Para. Let notice be issued. Returnable on 25th of July 2025. Who will accept? Mr. Nayak?
Not find it hearing for 2.
One Chief Secretary,
One is-
Burman.
Appointed.
Burman, 1,
1, 5 and
1, 5 and 6. Nayak, PWD 2,
2, 8 and 9.
2, 8 and 9. Revenue, PR Mohanta. Revenue 3, 4. And Airport Authority, anybody? Any standing council, Airport Authority? R. Dubey? Dubey appears for Airport Authority. Is it a standing council?
Lord, as per my knowledge. He was present.
Is Mr. Dubey the standing council?
Yes, please just send it.
Oh. He was yes, madam, you are with Dubey? Senior is a standing council, Airport Authority. Okay, you accept notice. Miss, your name? Miss N.B. Caster, Learned Council. For on behalf of RDB, huh? On behalf of Airport Authority of India. Extra copies by tomorrow.
My lord, the
All further actions taken. All actions taken would be subject to the outcome of this writ petition.
my lord, in the meantime, my lord, let me direct my lord to place the entire record for demarcation.
Let's see, let us see.
We'll find it.
File affidavit. Okay, next.
Obliged, Lord.
Item 9.
Thank you, boss.
Yes.
Matter is regarding no confidence matter. Initially, we came before this honorable court because they are not convening the meeting. Then this honorable court gave it liberty. According to my lord, ultimately this meeting was held by the requisitionist. You have to kindly see page 33, my lord. Page earlier proceeding.
Municipal board.
Municipal board. Page 33, earlier, my lord. 6 members are.
Yes, why aren't you holding the meeting, convening the meeting?
Yes.
How many of you are there? 5.
6. We are 6, total 10, 1 died.
No, you are 5.
The 5 petitioner, 1 is also there, my.
No, no,
MLA is there.
petitioners.
Yes, petitioner 5.
5.
5.
MLA is supporting you.
Yes,
Which constituency?
it is Satyabari Municipal Board.
Now, which constituency?
Your Lordship, huh? No? Shogugatti. This ultimately politics come, man. My one page 49, page
Yeah.
49. Man.
Your friend is laughing behind, Mr. Sharma. Mr. Sharma is very happy.
Yes, he is happy, madam. His man is there, madam MLA.
You are very interested in this matter?
He should be, man.
My lord, we are also a party in next similar matter. I do 13 one.
Similar?
9 to 13. Anyway, madam, I don't know that other one, but aspect is different. You were saying that.
Okay, we'll issue notice at this
Madam,
stage.
only page 49, madam. Just
49.
in the meantime, madam, the dividend may be given, madam. No bar in the company meeting. Madam. Page 49.
Heard Sri H.R.A. Chaudhary done its Senate Council for the petitioners. Full stop. The petitioners who are 4 in numbers,
5.
of who are 5 in numbers, are elected ward commissioners of the Horthebari Municipal Board in the district of Borpeta.
Yeah.
Full stop. It is projected that they had issued a requisition on 26/11/2024 for a no confidence
Yeah.
against the, for a no confidence motion
Yeah.
against the chairman. Full stop. The said notice was, however, not acted. Thereafter, the petitioners had taken further steps until now.
No, petitioner passed the resolution, madam. On 20 of themselves, they call the meeting. Page, your lordship, 37, 38.
Accordingly, the petitioners had, as no action was taken, the petitioners had convened
We have put
a
this on.
special meeting on 24/2/2025, and the no confidence motion was passed by secret ballot. Full stop.
And as per law,
However,
it is to be followed up within 45 days.
Thereafter, the vice chairman was requested to convene a meeting for election of the new chairman, which has not been done. Full stop. The petitioners had also approached the district commissioner Borpeta
On
for
34.
such convening, which has not been acted upon. Para. Let notice be issued, returnable on 28 of July, 28 তারিখ. UDD, madam. UDD, I think there is a standing council. P. Nayak, Mr. Nayak, he was here. Sri P. Nayak learned it standing council. UDD accepts notice on behalf of respondent 1 and 2. District Commissioner, Madam M. Borman, Executive Officer, Satyabari, who? Municipal Board, you? No, Executive Officer is a government servant.
Yes.
3, 4, 5 and 6, I think notice has to go. 3, 4 and extra copies. So far as 5 and 6, registered posted ready, huh? That's within 2 days, para. Pendency of this writ petition shall not be a bar for convening the meeting, which has to be done strictly in accordance with law.
By the district commissioner, my lord.
Next.
Obliged.
Item 10.
Lordship matter pertaining to compensation, your lordship. Your lordship, husband of the petitioner has been expired as a victim of murder, your lordship. And after that untoward incident, petitioner submitted an application before the respondent number 2 for compensation in terms of the Assam Victim Compensation Scheme. And thereafter also one application filed before the respondent number 3
for the same prayer, which was lying unattended, your lordship. Therefore, we are approached before the court. If you,
Where is the, where is your FIR?
we have annex police report, annex 3 at page 19, your lord.
19.
Yes, lord. Initially,
Your son has killed your husband.
yes, son along with his associate.
Okay. We issue notice, Mr. Sharma?
But certain, if your lordship come to page 23,
Yes.
the certain procedures is laid down. He has only filed a representation. He has to submit certain documents also.
Yes, lordship, we have annex with represent.
Heard.
And
Sri
the
S.
next
I.
to kin
Akan,
certificate that
learned
will also
counsel
be
for the
required.
petitioner,
Yes, sir.
who by means of this petition has prayed for a direction for payment of compensation
Okay.
under the Assam Victim Compensation Scheme, which was notified in the year 2012. Full stop. It is the case of the petitioner that her husband is a victim, and our husband was murdered. And in that connection, a police case was filed. Full stop. Para. Let notice be issued, returnable by 6 weeks. Sri H. Sharma, learned additional senior advocate,
1, 3, and
accepts
4.
notice on behalf of respondent 1, 3,
And 4.
3, and 4. 3 BTR,
He
District-
lordship,
District Legal Services Authority. I think you 1, 3, and 4. Arrest 2, and I think 3 also perhaps you can take. Only 2.
3 I can lord.
1,
As
3,
because he is
and
the
4.
officer in charge of.
1, 3, and 4 to Holu H. Sharma. Or what is your name? R. Chauhan. Sri R. Chauhan, learned counsel appearing on instruction of Miss R. S. Chaudhary. Accepts notice on behalf of respondent number 2. Extra copies.
So obliged.
11.
Yes.
Lordship. Lordship, I am a property proprietorship firm.
Yes, GST.
Yes.
Central or state GST?
State GST.
State GST. State GST, who appears? Mr. Chaudhary?
Lordship, copy has-
Copy not served.
Sir,
Served to whom? SCGST is written, Mr. Chaudhary. Give a copy to him. We'll have it after some time.
Yes.
After a while. Give an extra copy to him. Yes, next.
Item 12.
May I please,
Yes.
Lordship, here the grievance of the petitioner is there. Lordship, he lodged an affair, Lordship, before the concerned IC of the police outpost, which the concerned IC denied to register. Subsequently, he lodged
What was the
complaint.
offense?
Lordship, this FIR discloses exactly a cognizable offense.
What is the offense? Regarding what?
The FIR, Lordship, I have annexed in page number 12 onwards. Lordship.
12.
Yes, 12 onwards. Lordship.
Yes.
Page 13 with the FIR, Lordship. May I read first?
Yes.
Page 13, Lordship. Sir, I would like to inform you that with prior conspiracy, accused number 1 and 2, namely Akhirul Islam Farazi and Sultan Alam, respectively, went to the house of my son, namely so and so, at New Phegamari, and asked to contact me with them immediately for some serious discussion. Accordingly, on the same day, I contacted accused number 1 for 3 times on being informed by my
Okay,
son.
okay. Now what has happened?
Lordship, thereafter, Lordship, we lodged a complaint before the SP, which was also not, no step has been.
Yes,
not
yes.
taken.
You take instructions.
Lordship, apart from Lordship, this address already, Lordship, this issue already addressed by the Honorable Access Court, Lordship, in case,
Lalita.
yes, Lordship, where there is a cognizable offense.
Yes, that is why we have asked him to take instruction. Okay. Third three is that Ahmed, learned counsel for the petitioner, who is aggrieved by non-registration
Yes.
of an FIR which he had sought to lodge on which date?
Yes, Lordship, 16/6,
16/6.
2025.
16/6/2025. Full stop. The petitioner has also claims to have approached the Superintendent of Police, South Salmara Mankachar, on 26/2025, and even thereafter, no steps have been taken. Let notice be issued. Returnable on, we give a date, small issue. Returnable on 21st of July, 2025. Sri H. Sharma, learned additional senior advocate, Assam, accepts notice on behalf of all the respondents.
Okay.
Let extra copies be served upon him by tomorrow. Pendency shall not be a bar for registration of the FIR in accordance with law.
On spot date, because he is.
Short date is when?
On 16th.
From Saturday or with a holiday during this period.
Okay, we'll have it on, try on 18th. 18th. Okay. Get telephonic instruction.
Copy to the copy names and nothing.
Next.
Item 13.
I am appearing for the caveators, madam. There are 5. Today morning only copy of stuff, madam. Let me take tomorrow. Another.
We tried to furnish the copy yesterday, but the council, junior council, refused to accept.
No, anyway, he might have got, but I got it just in the morning.
Why do you refuse to accept?
My lord, I got a phone call on about 6 p.m. My lord.
The Lord will leave the court.
After lodging and complaint before the registry, my lord. That we are the caveators and the copy was served to us, and when I checked the policy, my lord, case was dismissed.
On receipt of, my lord, information from the registry that there is a caveator, because cause list, my lord, does not indicate there is a caveator. We, my lord, immediately, my lord, we prepared the copy and my lord contacted them. And it is not all, no fault on our part. Registry is also called up. Registry also, my lord, informed us that you copy, furnish the copy. Accordingly, we call them.
Okay, we can have it tomorrow?
Tomorrow.
Today, my lord, after 2.
At 2 o'clock?
2 o'clock.
There is another case, my lord. If that, we will accept that, their prayer, that may also take into that, they can, that may be allowed.
No, I to accord fix after. First August fix after.
We'll have it at
no conference, most of 15 August, there is stay. Whatever, my lord, let me tell.
No, then we'll hear him.
Yes, this is my case, my lord.
No, anyway, why I'm.
No, you now have,
No,
you'd
why
like to
I'm
do the
thinking
matter now or tomorrow at 2 o'clock?
Yes, my lord, one record may be called, my lord. Another case in connection with the same case, that may be allowed with that prayer. We don't even
How can it be?
No,
This is
not,
my case. Let me first submit my
we
case.
don't even know what is the case
Yes,
about.
No, whatever, just whatever seen over the extent of this matter, whatever matter, there is one conference motion, no conference motion given earlier. In that, it should have been attached to chairman to wrongly attached to the executive officer. Against that, they came and obtained the stay, and this pending. It is fixed in August. And the no confidence motion is held up. Now, my lord, we have given fresh additional chairman. Against that, they have come today. So far, I know what I read from. So, my lord, their prayer there was.
You are the chairman.
They
No,
had a request.
they
Malad,
are-
let me place my case, Malad. If my learned senior.
At 2 o'clock.
Yes, 2
At
o'clock.
2 o'clock.
Yeah.
2 o'clock.
With my lord, Vishnu also called my lord, 3274
Let us see if need be, we'll call it, not now. We don't even know the facts.
Right.
Thus, no confidence, after all, they will not face the pilot, no confidence. Dominant forces cannot be stalled at all. Only the technical defect was there, that's why they got to stay. Yet two.
Two, my lord. Malad.
Okay.
Fourteen.
1-4.
Child marriage, my lord. This Putas have filed after having known that he is a guilty of child marriage. We filed an application to the 6 page, my rule 62 for D of the Assam Panchayat. You can kindly have a look to that.
Voters, petition of voters of.
Page 52 is the petition, everything we have given, madam. Page 52 if you lost me.
Who are you?
We are the boot expert. We can come 62 for your law, kindly have to look at the rules.
How many votes did you cast?
Why not?
2 of the petitioners have cast 2 votes.
No, I am not on that. Anybody, madam, your law, kindly say, rule is there. Rules allow us to do, my lord.
Rule.
My lord, Panchayat. Asena, I mean, yes, my lord, 64.
Page.
Page 224, man. 223 your lord's kindly. 223. Not 222.
64.
Yes. Yeah. 62. Your lordship will find 60 page 223 and 20 C and D your lordship kindly. D, we are on D, my lord. The executive officer, your lordship got it, man. The executive officer of Anchal Panchayat on receipt of information of such underage or the minor marriage in respect of the president, vice president, or member.
You are reading where?
I am reading D, my lord, 62, page 224. If this is the book, my lord.
Yes. D.
D. Small D.
Okay. Gaon Panchayat.
Gaon Panchayat. No, yes,
D.
yes.
Executive officer.
Yes, executive officer.
On receipt of information.
But the two things. One is before election, at the time of nomination, they can file.
Please read D.
Yeah, the executive officer, it is post election, after election.
Yes.
The executive officer of the Anchalik Panchayat on receipt of information of such underage or minor marriage in respect of president, vice president, or member, we are on member of the Anchalik Panchayat, shall inform the matter to the concerned district commissioner through CEO. The concerned, CEO Jila Parishad. The concerned district commissioner shall examine the matter and on establishment of fact shall remove the president, vice president, AP member accordingly and inform the matter to the state government and shall state election commission Assam. Now page 52, your lord's kindly see.
50?
52.
Of your petition?
Yes, ma'am. In terms of this, we file this in exactly 52, ma'am. Page 52.
52, yes.
Yes. So, your lordship, all details I have given, including the provisions of law also, my lord. Nothing has been done till today. This is my
The prayer.
page 56 is the prayer, your lordship. Type C. 557. Yeah. And they acknowledge it, my lord, the seal signature, page 50 is there.
Where is the substantive provision in 62?
Yes. From the main disqualification page, it will come, my lord, 111 to F of the Assam Panchayat Act. disqualification part comes now. And 62 main, my lord, your lordship will find, 62 qualification is 62 conditions and procedure of disqualification
Yes,
under
which-
subsection 2.
Which part? Which
Uh,
part? That is what.
Your lord kind of say page 220.
And the.
22062.
No, first, of the act, which provision?
Yes, it is there in page 62.
No, of the
Yes,
act.
1 some Panchayat Act 1994 as amended. Section 111.
11, which one?
2 surplus 2.
Surplus 2?
Surplus to F.
2F.
F point.
Who either by himself
Yeah.
or herself or his or her spouse has violated the legal age
Yes. Under the prohibition of Child Marriage Act.
means what is the meaning?
What? Either by himself or herself or his or her spouse has violated the legal age of marriage under the prohibition of child marriage.
Yes. What is their rule? In a child marriage,
Yes.
what is their role? The role of the private respondent.
For private respondent, madam, he is the elected person. Suppose
What is their role in the child marriage, which you have alleged?
herself solemnized. She is the wife. Her marriage was by the underage, 16 years age. She herself, private respondent.
She was not 16 years
Yes,
at the
not-
time of marriage.
Yeah.
Yes.
This is the case, madam.
You have a state election commission. You have a role. Who has a role?
They have to inform the.
Okay.
We did it.
Okay. Heard Sri H.R.A. Chaudhary, Learned Senior Counsel for the petitioners
Mr.
who are assisted by Sri M.K. Hussain. क्या बोलो? Hard to censor, by petitioners who are aggrieved by the inaction on the part of the respondent authorities to consider and take steps on the application dated 35/2025. Full stop. The petitioners have are trying to invoke the provisions of rule
62, madam, page 52, your lord, this one. 62 within bracket 4 within bracket small d. Page 52.
provisions of rule 62 within bracket 4 within bracket small d of the Assam Panchayat within bracket Constitution rules 1995 read with section 111 bracket 2 bracket small f of the Assam Panchayat Act 1994.
As amended.
So it is the case of the petitioner that the private respondent
6.
does not is disqualified under the aforesaid provision, and yet no action has been taken. Para, that notice be issued, returnable by 6 weeks. Miss, yes, Madam Thapa, P. Thapa, Learned Counsel appearing on instruction of Sri S. Datta. Standing Counsel PNRD accepts notice on behalf of respondent 1,
4 and 5.
1, 4, and 5. Sri R. Dubey, Learned Standing Counsel, State Election Commission for respondent number 2.
Yes.
Sri H. Sharma, Learned Additional Senior Advocate for 3. Extra copies. Steps for service of notice upon respondent number 6 by registered post with AD. Steps within 2 days.
Madam, pendency, madam. Your
Pendency shall not be a bar to take action in accordance with law.
obliged to.
15.
In the instant petition is filed, explaining the or action of the respondent authorities. In this case, on 12/12/2024, the respondent authorities have conducted a search when the premises of the petitioner. After that, they have
CGST. Madam, who's for CGST? Mr. Kyle?
State GST.
State GST? State GST?
I found a very limited player, Lordship. Lordship, after the search was conducted,
We have it at 2 o'clock, Mr. Ali?
coming up.
We can have it at 2 o'clock if you want
No,
to.
Lordship, I know it. Lordship, here, there is a provision under section 107 for to go on appeal. It appears that they are agreed by the seizure and the proceeding thereafter.
I have
No,
a
he is
limited
more on the aspect of procedural fairness. He was not given documents at the
Lordship.
time of hearing.
Yes, Lord. But that is statutory right under section 67(5), Lord. So I am humbly requesting them to
But this ground you can also take in the appellate forum.
by filing an appeal, Lordship, in my pleadings, I'll have to rely on my documents, Lordship. So if my pleadings are incomplete, Lordship, tomorrow they will take the ground that I have not taken those grounds in the appeal. So that being a statutory provision and also held by various high courts, Lordship, that when I am being directed by
Yes,
the
sir, we'll issue a short notice. Heard Sri A.I. Ali, learned counsel for the petitioner, who is aggrieved by the issuance of a summary show cause notice on 29/5/2025 and demand of tax, interest and penalty, wherein the last date has been fixed as 29/6/2025. It is the case of the petitioner that the proceedings were held without giving a fair opportunity to the petitioner to present his case, as no documents were supplied to him. Para, let notice be issued, returnable by 4 weeks. Sri B. Chaudhary, learned Standing Counsel, Finance Taxation Department, accepts notice on behalf of all the respondents. Let extra copies be served upon him by tomorrow. Para, Sri Chaudhary, Sri Ali, learned counsel, prays for an interim order. On the other hand, Sri Chaudhary, the learned standing counsel, has submitted that there is an alternative
Remedy under 107.
alternative remedy in the form of an appeal under section 106, 107 of the Act, Para. Balancing the equities, it is directed that till the next date fixed, no coercive action be taken against the petitioner.
Lordship, let it be after 3 weeks on a reopening. I can
3 weeks. They will fix a date also. List on 16th of July.
Yes.
16th July, Wednesday. 3 weeks. Yes, next.
52 subsidies.
I filed the application for impleadment.
Heard Sri S. Sahu, learned counsel for the applicant, who by means of this application has prayed for impleadment of the Maintenance Tribunal Dhubri as party respondent number 3. Para, considering the subject matter of the repetition wherein an order dated 35/2025 passed by the said tribunal is the subject matter of, has been challenged, comma, the impleadment application is allowed. Accordingly, the newly impleaded respond number 3, accordingly, the maintenance tribunal Dhubri so-and-so is impleaded as respond number 3. Para? No, in the main writ petition you write, heard 3S Sahu learned counsel for the petitioners who are aggrieved by it first para when this matter was taken up on 23/6/2025, it was noticed that the concerned tribunal was not made a party respondent. However, while an order passed today in the connected IA Civil 2083 of 2025, the said tribunal has been made a party respondent number 3. Para. Let notice be issued, returnable by 6 weeks. 3. Yes, Mr. Sharma? Sri Sharma, Learned Standing Council, Social Justice and Empowerment accepts notice on behalf of respondent number 1. Let steps be taken for service of notice upon the respondent numbers 2 and 3 by registered post with AD. Steps within 2 working days. The petitioner, Learned Counsel for the petitioner is also required to file amended cost title. Para. 3. Sahu, Learned Counsel praised for an interim order. Para. Prima facie, comma. The tribunal may not have a power to direct eviction. Para. In that view of the matter, the impugned order dated 35/2025 passed by the Learned Maintenance Tribunal Dhubri in application number so-and-so shall remain suspended. Full stop. Para. It is, however, provided that since the present order has been passed ex parte, comma, the respondents may come up for modification, alteration, if so advised. Public. You file amended cost title order, then you take steps.
53.
My lord, 220% similar matter is pending. You have been issued eviction notices, so some lands are patta land.
Proclamation, madam?
Yes.
Okay, same order will pass.
Same.
Mahmood? Or will if I'll let you know? Petitioners, huh? M. Kolita, Miss M. Kolita 1. Revenue, Borpujari 2. Madam 1, 3, 4.
4 and 5.
4 and 5. Revenue, respondent number 2, Borpujari. Then 6, 7 and 8. H. Sharma, additional senior advocate. And APDCL, Mr. Chaudhary. B. Chaudhary, 9. And Chairman, Gwalpara Development Authority. Chairman, Gwalpara, I think, Mr. Sharma. Gwalpara Development Authority Chairman. Secretary, Harimura Gaon Panchayat. Secretary, US Government, Panchayat and Rural Development. Yes, Mr. Dotto, 11. 11 as Dotto. 10 you have to take registered post with AD. 10 by registered post with AD. Extra copies, okay. Baki to order is you don't have much of a road, but still then SCP and RD may be reflected. Which order should he pass, madam?
The first one was
Sahabuddin.
The second one was in that.
We have also given similar.
Similar order pass koriba. Okay.
Impute notices page 93
Okay,
and
okay, we'll pass,
99.
we'll pass similar orders. বাকি
Public.
করিবা interim order আছে হ্যাঁ
Right.
সব কিন্তু অনেক আছে না মুখ দেখাই লব লাগে
54.
May it please your lordship, my lord, matter relates to my lord, availment of ITC, input tax credit. In fact, matter is squarely covered by division bench decision.
Yes, what do you say?
We need some.
Okay, we'll issue a short notice then.
Till then, my lord, no query.
So lordship, alternative remedy is also there. They have challenged order in original. They
Hard.
have-
Sri A. Goel, learned counsel for the petitioner who has put to challenge
Annex 3.
an order dated
15/12/2023.
But why are you so late?
My lord, it was communicated very late, your lord.
When?
And that's why I have to.
15/12/2023.
that is not maintained.
That's why, my lord, they have not proceeded also. That clarification by way of additional affidavit.
Whereby a demand has been made, full stop. The learned counsel has submitted that similar matters have been decided by the Honorable Division Bench.
Case 70.
Para. On the other hand, Sri Jain,
Lordship.
learned counsel assisting, appearing on instruction of Sri Srikal,
Lord.
standing as senior standing counsel, CGST,
CGS.
has raised the preliminary objection on the ground of maintainability by contending that an appellate forum is available. Full stop. He has also raised the issue of delay in making the present challenge qua an order passed in the year 2023. Para. Be that as it may, let notice be issued returnable by 6 weeks. Sri Jain, the learned counsel, accepts notice on behalf of all the respondents. Extra copies. Para heard the learned counsel on the interim prayer. Para. After hearing and upon balancing the equities, it is provided that till the next date fixed, no coercive action be taken against the petitioner.
Deep.
55.
Yes.
May I please, as your lordship? My lord, my bank account, my lord, which I am operating at the HDFC Bank, Hathigaon branch, my lord, had been freezed. My lord, without affording me any opportunity of hearing or no notice had been served. My lord, when I inquired into the bank, my lord, they have issued a letter to me, my lord. My lord, may be pleased to find the impugned letter is at page 24, my lord. State that, my lord, 13, my lord, fraudulent transaction in the nature of cybercrime, my lord, had occurred in my account, my lord, and that's why the Chennai police is investigating, and there is a direction from the police to freeze the account. Now, my lord, when I inquired, my lord, a customer has, I am operating a business of medicine, my lord, pharmacy. A customer did purchase an medicine from my account, and he did the online transaction of just an amount of rupees 450. Now, that person, my lord, perhaps involved with the some, my lord, cyber crime, my lord. For that reason, my lord, I have been freezed the account, and the whole business as well as my livelihood, my entire transaction depend on this account, my lord.
Livelihood depends on an account. Why?
My lord, if my lord may be pleased to find, my lord, I have
How many
stated-
accounts do you have?
My lord, at this moment, this is the account which I am holding, my lord.
Only account?
My lord.
Where have you disclosed?
No, my
That
lord.
this is the only bank account you are having?
No, my lord, the paragraph 6, my lord, I have disclosed that.
What have you said?
However, what type of difficulty, my lord, I am.
No, we are not on that.
No, my lord, other bank account, my lord, I have not taken the instruction, and I have not, my lord, pleaded in my petition also to be
What is
fair.
the amount deposit in this account?
My lord, certain
How much is the amount?
Total amount deposited, my lord. That has not disclosed, my lord, to
You
me.
have to disclose those. If it has got 100 rupee.
My lord, then it will have no bearing. But my lord, may kindly appreciate the paragraph 6, my lord, which I have stated.
Okay, we'll issue notice at this stage.
My lord.
But I don't have a case. If you have to, if you want some relief, you have to make out a case. This is my only account.
My
This has got this much of a, and all my transactions are done online.
My lord, I have.
Where have you done?
I have stated in paragraph 6, my lord.
What have you stated?
That the aforesaid, if my lord may be pleased to
They have read your paragraph 6. You have stated nothing.
Huh?
What have you stated?
My lord, from paragraph page 9, para 6, that the petitioner begs to humbly submit before this honorable court that however this so assistance with regard to his letter dated and his aforesaid bank account is freeze status till date. The petitioner has
The
been
business loan,
lord.
auto loan, car finance loan are of in connection with which account?
In this account, my lord.
Oh, these are separate accounts.
No, my lord. From this account, all these transactions are going on as an auto debit, my lord. From this HDFC bank, my lord. Current bank account of the petitioner in HDFC Hathigaon branch, my lord, which has been freezed, my lord. So, my lord, every
Disclosure is not enough. Okay. Third, Sri A.R. Bhuya Learned Counsel for the petitioner who is aggrieved by the action of freezing the bank account of the petitioner in the Hathigaon branch of the HDFC, full stop. On inquiry, comma, the petitioner has been informed that such action has been taken pursuant to a direction by the Cyber Crime Police Station, Veperi, V-E-P-E-R-Y, Chennai.
My lord.
Full stop. The petitioner apprehends that certain transaction by a customer may be the cause of such impugned action for which the petitioner cannot be faulted with.
Well.
Para, let notice be issued, returnable by 4 weeks. That's for 1, 2, and 3, 1 and 2. 1, 2, and 5.
Yes.
Extra copies, huh? Baki gote kata koi diba, huh? Registered post PTD.
4 to 8, my lord.
4 to 8.
My lord.
3 also.
My lord. My lord.
3,
3, 4.
3, 4,
6.
6, 7, 8.
8.
Steps within 2 working days.
Yes. Obliged.
56.
Yes, what is this?
In this case, there is on behalf of restaurant 9 and 10, I have filed a KVA, it's not there.
Have you served copies or not?
Yes, yes.
When do you want? Tomorrow?
I've already served. Already served.
Oh, okay, okay. Okay, doesn't matter.
6 numbers of petitioners are before your lordship, Lord. The first
Yes.
first meeting of the Panchayat was called on lordship, held on 21/6, lordship.
How many petitioners? 6.
6 numbers.
Yes.
The first meeting was held on 21/6, lordship.
Yes.
Wherein all the 10 elected members took oath, Lord.
Yes.
And thereafter, lordship, 2 names were proposed for the post of president and vice president, lordship. Accordingly, election was held. And our contention is that in the election, lordship, we 6 casted vote in favor of petitioner 1 and 2 for the post of president, lord. President and vice president. But authorized officer altered the result, Lord. Tampered with the ballot and altered the result.
You file a civil suit?
Lordship, there is legal remedies also there, Lordship. As per statute section 11, Lordship, district commissioner is the authority to decide the dispute. We have filed representation before the district commissioner. But that has been forwarded to the co-district commissioner, Lordship, page 37. If the co-district commissioner decides the same, Lordship, that will be non-act in the app law, because specifically district commissioner is authorized law.
Yes, yes, Mr. Das.
Yes, but district commissioner may be directed to dispose of our district.
The allegation with tampering by the circle officer, man. It is triggered, I'll get the instruction. Let it be up.
No, what Mr. Hussain is saying, that his approach to this court is only on a limited purpose. He wants the grievance which has been expressed before the appropriate authority, namely the district commissioner, should be looked into by him.
Yes.
If he delegates the power to the co-district commissioner, the results will not have any meaning tomorrow.
Let it be after my vacation.
Yes, what do you say,
Regarding this.
Caveator? Who are you?
9 and 10, duty that. Beside the meeting was that it's put your, when it came out, they put signature all that. And that coming out of the meeting was that
Lordship, see,
delegation, proceeding of the meeting.
How many days have you sat in the chair of the president? When was the meeting?
21-6.
21/6. Today is what?
25. Lordship,
From
E-
21 to 25, how many days were holidays?
4 days. Lordship, election should be by secret ballot. That is-
21 was a Saturday, 22 is Sunday, he could not sit. He said only for 3-4 days.
But he is not having majority. We are 6, Lordship, before this honorable court, Lordship. That section 11.
Mr. Chaudhary,
Same nature, my lord.
you don't like his client. You don't even allow him to sit for 4 days. Only 4 days he has sat.
My lord, what is to be done, my lord? Administration always in every time they intact, my lord. Completely reverse, my lord.
But he's saying something else.
It is not for the proceeding.
There was no objection or any grievance inside the hall.
No, my lord, that already, we have booted, my lord. We cast our vote, so there is no, subsequently we came to know why this happened, my lord.
It was a secret ballot, wasn't it?
It was second development. This is the point they have taken advantage of this point. Most of the places this is happening, my lord.
Tomorrow, if the ballots are seen that you have casted vote in his favor, then
No, that is another, if it goes against you, no, but I have nothing to do, man. Let it be transparent.
secret ballot is secret ballot.
Yes, but my lord, all time, my lord, everybody is before your lordship, fine. 6.
এখন caveat খন আনি দিবা, হা?
Idiot number.
By
5
the president and the vice president. Okay. Your S. Islam.
Yes.
Heard Sri S. Islam, learned counsel for the caveat, who has lost this caveat in respect of the matter of election of president/vice president in the, for the what?
President Baligao Gao Panchayat.
For the 71 number Baligao Gao Panchayat.
Yeah.
In the district of Darang.
Yeah.
The caveat would be heard in the event, huh? Well, caveat stands in charge. Do kono se beleg. Well, the main representative heard Sri H.R.A. Chaudhary, Learned Senior Counsel, assisted by Sri M.I. Hussain. M.K. Hussain, Learned Counsel for the petitioners. Full stop. The petitioners, who are 6 in numbers, has projected that they are elected members of the 71 number Baligao Gao Panchayat.
Yeah.
And on 21/6/2025, the first meeting was held wherein the election for the post of president and vice president was conducted. Full stop. It has been alleged that though the petitioners had cast their votes for the petitioner numbers 1 and 2, respectively, for the posts of president and vice president, there was certain tampering for which the respondent number 6 and 7,
6 and 9 and 10.
9 and 10. Who are 12, 11 and 12?
Other members supporting them.
Respondent numbers 9 and 10
Other members
have been
supported.
shown to be elected. Full stop. In this connection, comma, the petitioners have also submitted a
Page 37,
representation
Page 37.
before the district commissioner, who is the appropriate authority. Full stop. The
Section 11.
the petitioners have, however, been informed that such representation has been such representation has been now forwarded to the co-district commissioner,
For inquiry, my, for inquiry.
commissioner, who is not the appropriate authority.
Yes.
Para? Per contra, 3, and thus London State Council has submitted that the matter is being looked into by the appropriate authority, and only the enquiry has been sought to be conducted by the co-district commissioner. Para? Let notice be issued, returnable by 6 weeks. Panchayat, Sri S. Dr. Leonard, Standing Council, Panchayat and Rural Development accepts notice on behalf of Respondent 1, 1, 4, 7 and 8. State Election Commission, R. Dubey, 2. And yes, the State Council,
3, 5, 6.
and thus 3,
5, 6.
4 also matters.
3, 5, 6. Then Executive Officer, you have already taken, I think. 8 to
No, my lord.
12.
8 also government.
8 also, okay. 9 to 12.
Yes.
They start post to 80 steps within 2 working days, huh? Para?
9 and 10.
Oh, sorry. 9 and 10. Yes, Islam, huh? Caveator. 11, 12 registered and posted AD. Extra copies are reflective. Steps within 2 working days. Para? Penalty shall not be a bar for disposal, for consideration and disposal of the representation
By the district commissioner.
by the appropriate authority in accordance with law. Representation dated? Representation dated?
Representative dated my lord
21.
21/6/25.
21/6/2025.
Till then, my lord. Till then, my lord, 6%, my your lordship. Democracy is there, my your lordship knows how this thing is misused by law.
Only 6 weeks. Before that, I think the order, you have to challenge another order.
And materially, there may be, my lord, there again, but otherwise, my lord, party will suffer.
Let us see.
But the date may.
At least on 6 weeks, please, na? Adik Manhol. 25.
Huh?
We'll have it on 1st of August. First 1/8.
1st of August, my lord.
6 weeks. 6 weeks, 1st of August is.
Let it be 4 weeks, my lord, your lordship. Your lordship,
4 weeks, then we'll have it on 30th of July.
I leave to your lordship, my lord.
4 weeks.
But one day, my lord, respondent 10, 9, 10,
11, 12.
11, 12, we may be allowed to dust this agreement.
11, 12 additional dusty koriba. Rotate through the sense. Notice to give the date. Next date sense. Okay.
All right.
11, 12 dusty allowed.
57.
Huh? 30 August na? 30 July.
May I please, your lord?
Yes.
My lordship, our household premises are situated on village reserve forest, my lordship. It's a government land, my lordship. While annexing several documents of 1951, my lordship, we have been stating that our forefathers had settled in the government land, on the government land, for being victim of river erosion of Brahmaputra River, my lord. Thereafter, we have been staying for more than 50 years, and the government land has been declared as BGR, with in violation of section 13 of the regulation, my lord, because no notice and nothing has been issued. We don't know anything, my lordship. All on a sudden, my lordship, the impugn notice has been issued asking us to vacate the land within 30 days.
the impugn notice which we have annexed, my lordship, on page 58, one of the
Yes.
58, my lord. So our grievance is that, my lordship, we are landless person, my lordship. Even there is a scheme also, my lordship, landless. VGR, my lordship, can be allotted to landless person, those who are
VGR
village grazing ground, my lordship.
can be allotted.
Yes, my lord.
Under what provision?
My lordship, kindly see page page 60, my lordship, and Excer 4, my lord.
60?
Page 60, my lord.
60.
60.
Yes,
This
please.
is the notification, my lord.
Yes.
May I read? The government of Assam is pleased to introduce a scheme called Chief Minister's Special Scheme for Rehabilitation of Erosion Affected Families in Assam, in order to rehabilitate homeless and landless person, people living on embankments, roadside, educational institutions, religious organizations, shore and forest land, government lands, BGRs, TGRs, etc.
Yes.
My
For
lord.
rehabilitation,
My lord.
not for allotment of VGR land.
My lord. Rehabilitation. That is my
Rehabilitation.
my lord.
You cannot be allotted
Misplaced,
VGR
my
land.
No, my lord. Rehabilitation. We are speaking rehabilitation because, my lord, NRC also, NRC document of 1951,
But
we have annexed.
VGR, Jakpal is very clear. We cannot go beyond Jakpal.
My lord, I have annexed the NRC of 1951, my lord. From more than 50 to 60 years, our forefathers has been staying, my lordship. And
will it give you any right if you are
my lord,
encroaching
no
government
right,
land?
but my lord, no rights given, my lord.
How can you claim a right?
But at least rehabilitation, because we have no place to go, my lordship. And NRC 1951, I have annexed, my lordship. Our names has been.
First of all, my lord, copy has not been served to us. Anyway, my lord, if lordship may be pleased to come, my lord, to that eviction notice, my lord, as page 58,
Yes.
which lordship has seen.
Yes.
My lord, it is, my lord, issued by Circle Officer Rongduli Revenue Circle.
Correct.
Rongduli. So, over part and parcel of land, my lord, where they are in occupation. That land is also described, my lord.
Yes.
VCR Dag number so and so, Konakata Part 1 Revenue Village under Rongduli Revenue Circle, Goalpara. Now, lordship will kindly see, my lord, the ration card. Ration card, my lord, at page 56.
Yes.
Page 56, 57.
Yes.
There down below, lordship will kindly see Dudhnoi. Number and name of LSC.
Yes.
Name of Gaon Concert, Simitola.
Permanent address, Kankata Part 1. All are Kankata Part 1.
Now, these documents does not give them any right of occupation over VGR land, number one. Number two, they have annexed this rehabilitation scheme. To my lord information, this is no longer in force right now. And even if it is assumed that some scheme is there under the land policy, they also have made any application, because prolonged occupation over any VGR land will not, if effect, to give them any right. There is no document on record whereby it suggests, my lord, that they have applied before the authorities taking
Have you
allotment.
applied?
No,
Kindly see Rule 18, my lord.
Have you applied?
My lordship.
Not applied.
All on a sudden, my lordship, this notice has been issued, my lordship. We are getting rations and every ration from the government. My Rule 18 may be seen, my lordship. Kindly see, my lord.
Rule 18 of?
Of the land revenue, Assam land revenue regulation,
Yes.
1886.
Yes.
Rule framed under Rule 18 may be seen. Rule 18 regarding exactment, my lordship.
Yes.
According to
18 has been read, reread.
This
explained.
is
We
Deputy
don't have
Commissioner
to
is the
read 18.
competent authority, my lordship. Deputy Commissioner is the competent authority. And my lord, Rule 13 also, Section 13, read with Chapter 2 and Part 2 may be seen.
Sri
my
SB
lord.
Laskar Learned Council
No interim pen.
for the petitioners who are aggrieved by an eviction proceeding which has been initiated, wide individual notices dated 2/6/2025. It is the case of the petitioners that they are in possession of government land since a long period of time. The Learned Council has also raised the issue that though the land in question has been described as VGR land, there was no prior notification
Yes, my lord.
of such declaration. Para. Let notice be issued, returnable by 6 weeks. 3. Our proprietary land standing council revenue accepts notice on behalf of Resona 1
One,
and 3.
my lord, only one, my lord.
Assistant settlement officer?
Three,
No.
four.
2, 3, 4 each, Sharma, additional senior government advocate. 3. Laskar the Learned Council prays for an interim order. Para. Which has been strenuously objected by the Learned Council for the respondents. Para. The notice impugned in this proceeding clearly describes the land as VGR land. Full stop. Long possession of such VGR land shall not vest any right. Prima facie shall not vest any right as held by the Honorable Supreme Court in the case of Jagpal Singh versus State of Punjab, reported in 2011.
2011.
In that view of the
SSC
matter, this court
396.
is not inclined to pass any interim order.
Yes.
Yes, next.
So applies.
58.
My lord, the petitioner as a plaintiff filed a suit for right title, interest and confirmation and filed an application for injunction. The respondent number 4 also filed a written statement and also filed an application for injunction. And thereafter on 27/4/23, page 60 is the order path. Before I proceed, I want to place one thing before your lordship. The district commissioner is also a party to the suit. My lord, I have, in my plaint, your lordship will find. In the plaint, your lordship will find page 13, they are party to the suit.
Yes.
Now,
Defendant
page-
number?
My lord,
Defendant number?
dependent number 4, private respondent,
No, the district commissioner.
the pro forma dependent number 1 and 2. And the main defendant number 1 and 2 also filed an application for injunction.
Okay.
And ultimately at page 60, the order was passed by the trial. And the plaintiff petition.
60 years.
May I read it?
Yes.
Petition. Huh? And I was ultimately, my lord, the status quo order was passed at page 62. Your lordship will find. The petition, first paragraph, middle portion, I'm reading, my lord. The petitioner has also
No,
made
the status quo has been passed.
status quo has
Thereafter,
been
what
passed
has happened?
in the application for the dependent. In the application for the dependent, status quo order has been. That is at page 63. Your lordship will find.
Yes.
My lord, that portion I will read it, my lord. This court is of the opinion that at this stage, there is a necessity to protect and preserve the suit property by way of an ex parte ad interim injunction, directing the parties to maintain status quo over the suit land till disposal of the missed J case so filed by the petitioner defendant. So, my lord, that was the order passed in page 60.
Yes.
Now, my lord, suddenly, after obtaining a status quo order, they went to the circle officer and filed an application for demarcation. And your lordship is well aware of section 21 to 24 deals with the demarcation. And in 23,
yes,
the position can be held after demarcation may held. So, my lord, my prayer at this moment is against this notice, because when there is a civil suit pending, revenue authorities are part. Status quo order is there. The revenue authority should not proceed with the demarcation.
Where is the proceeding, or from where are you making the averment that they are proceeding?
My lord, that is at notice, although I have not received, I have collected from somebody. That at page 65.
Then there'd be a violation of the status quo. You apply for under
Well,
the appropriate
because-
provision of law.
My lord, now my only thing is this order.
Won't this amount to multiplicity of proceedings, number one? Then the matter has been looked into by a civil court. your injunction application is pending, and their injunction application is the order of status quo. If status quo is there, how can demarcation be done?
And
that is your contention.
My con.
But this, why should we reiterate?
Because, my lord, if your lordship on a violation of injunction orders, notice will go. In the meantime, my lord, under 21 to 24, they can, in 23, section 23, they can hand up opposition.
Can't you file an application in the learned in the court of the civil judge?
My lord, because in my application is already pending. It is in.
No, is there any bar for filing another injunction application? You can.
My lord,
you can file another injunction application.
My lord, here my case is this because injunction application against the demarcation notice against the revenue authority. My lord, other alternative questions will come. But my only question whether
no, if you see, you may be correct in contending that the approaches may be different. It may not be a civil court per se, but the matter has been looked into by the civil court, where you have admittedly have said you have filed for right title and interest with an application for injunction. WS, they have an application for injunction. Their injunction application, this order has been passed on 27/4/2024 of status quo. Now there is some
27/4/23.
23 you have said, yes. Now after around 2 years, there is some development for demarcation.
And my lord, now on 36, my lord, they will come for the boundary demarcation on 36. Because by the
yes, Mr. Barbujari.
Because my for a moment, my lord, my whole contention is this, my lord. Though there is not be an absolute bar, but the revenue authority should not proceed when a civil suit. They should send us to the.
Why should a writ court say that?
Well, because as per the land
court?
and revenue regulation, my lord.
Now, why should a writ court?
Because this notice is bad because it is without jurisdiction. My submission is this: this notice is absolutely without jurisdiction.
Yes.
I could have appreciated this argument if the next civil court below had become a court of pancas office.
No,
it is
session of the matter.
Session of the matter. Appropriate provisions are there available in the court.
You approach the civil court.
My lord, because my lord, your lordship will just look into on 36 is their date. My lord, civil court, my lord, I have to approach, I have to give them copy. Next date will be fixed.
Why? You can move it. You can move an injunction. It has not. It's not.
Because my lord, my application was already pending. No order has been passed. And
you can file another application.
My lord, here, if your lordship gives me an opportunity that I will file an application, but nothing will be done on 36. That much I need. My lord, 36 is very near.
Okay, we grant some time. Okay.
Give me some time.
Sri P.K. Roy Chaudhary, Learned Counsel for the petitioner. Also heard Sri R. Borpujari. You waited till the vacations to move this kind of a case.
My lord, my pain is very.
What is plowing the ground?
We have seen such type of things for a long time, so it will not affect us. But still then, little bit of.
So many provisions are available under the code.
Counsel for the petitioner. Also heard Sri R. Borpujari, Learned Standing Counsel Revenue, as well as Sri H. Sharma, I believe. Revenue Audit, as well as H. Sharma, Learned Additional Senior Advocate for the state official respondents. Para? Oh, there is a private respondent.
Yes, private respondent.
That is the problem.
Considering the subject matter involved and the order which this court proposes to pass, notice may not be required to be issued to the private respondent, and the writ petition is taken up for disposal at the motion stage. As per the facts projected, the plaintiff and the petitioner, as one of the plaintiff, had instituted title suit. Please have your seat. Had instituted title suit 38 of 2023 in the court of the Learned Civil Judge, Borpeta, for declaration of right, title, and interest and also for cancellation of mutation. Full stop. Along with the said suit, an injunction application was also filed, which is pending disposal. Full stop. The private respondent number 4 had filed written statement along with an application for injunction. Full stop. The learned court, by an order dated 27/4/2023, had passed an order of maintaining status quo in the application filed by the respondent number 4. 4. Para. It is the case of the petitioner that during the pendency of the suit, the private respondent has filed an application for demarcation, and very recently the petitioner has come to learn that 30/6/2025 has been fixed for such demarcation. Para. It is the contention advanced by Sri Roy Chaudhary, the learned counsel, that the matter being adjudicated by a competent civil court, such action by the official respondents to proceed with the demarcation would not only be prejudicial, but would also cause irretrievable loss and injury. Para. On the other hand, both Sri Borpujari as well as Sri Sharma, learned counsel, has resisted the prayer by submitting that the approach to a writ court in a matter of this nature is misconceived, and in case of any grievance, the petitioner can approach the civil court which is in session of the matter. Para. This court, after considering the rival submissions, finds force in the contention advanced by the learned counsel for the respondents. Full stop. This court is of the opinion that when the entire dispute is the subject matter before the competent civil court in title suit 38 of 2023, any further grievance has to be raised before the said court by filing separate application. Full stop. Though certain apprehension has been raised by the learned counsel for the petitioner that his earlier application under Order 39 Rule 1 and 2 is still pending, this court is of the firm opinion that there is no bar for filing another application in view of the present development. Para. In view of the above, this court disposes of this writ petition. This court is of the opinion that this petition is not required to be entertained. Full stop. Accordingly, the same is dismissed. Full stop. However, be dismissed by giving liberty to the petitioner to approach the competent civil court within a period of a week from today. Is there any summer vacation in the civil court?
No.
Within a
10 days from today, and
in a period of 10 days from today. Full stop.
and
To balance the equities, however, it is directed that till 10 days from today, which is that is today's 25th.
10th July.
Not 10 July, 25th, till 7th of July. 7th of July. To balance the equities, it is, however, directed that till the date fixed, that is 7th of July, no action be taken for demarcation. Full stop. In the event an application is filed by the petitioner before the learned civil court, the same be considered strictly in accordance with law.
Can I make clear that dismissal order may be put to disposal? That much liberty may be given to us.
Closed.
Closed. Closed. Closed.
Item 11, line B.
Lordship, we have stopped it.
What is this, Mr. Chaudhary?
Lordship, it appears from the pleading that the GST authority detected some fraud and inquiry is going on. And on the last occasion, that is at page 26, he has been asked to produce some document.
Yes. Have you produced those documents? Item number?
11.
Lordship, in this regard, we have taken an interim participatory bail application. We filed it at the District and Session Judge Court, and which we will appear shortly within 10 days.
No. Have you filed the documents? You were asked to.
Yes, we will appear. Your Lordship, we appeared on 31st. On the 31st, we were supposed to appear on 31st. I appeared through my counsel. Personally, I have not appeared yet. I will appear.
No. What is your prayer before this court?
My prayer is that Your Lordship, there are, if I may take you to annexure H, page 55. While this summon is still pending, Your Lordship, they have filed another summon on 28 again. That is annexure C. On the same dispute, Your Lord.
Let us see your prayer at page 9. Revoke the suspension of the GST. Revoke this.
Bank account has also been freezed, Your Lordship.
We'll issue notice at this stage. Let us examine. Heard. Sri Jirengma.
Yes.
Learned counsel for the petitioner, who is aggrieved by the action of the state GST to revoke by the suspension of the registration and further action of attachment of the bank account. Full stop. The proceedings initiated under INS 01 has also been put to challenge. Let notice be issued, returnable by 4 weeks. Sri B. Chaudhary, Learned State Standing Council, Finance and Taxation, accepts notice on behalf of both the respondents. Let extra copies be served upon him within 2 days. Yes.
Item 16.
If this matter could have taken up for disposal, final disposal, but the rejoinder affidavit is not on record matter. It was filed on 16th of May. I have checked matter, it is not on record.
What is this matter about?
But if in this case, prior to the provincialization, the Guwahati Madrasa High School, the petitioners were tenants. Prior that tenancy was prior to the school being provincialized. But thereafter, my lord, eviction notice were issued.
Against that, my lord, this writ petition has been filed. Because once a person is tenant, only procedure for eviction is the procedure prescribed under the Aadhar.
Now, what is there anything surviving?
Yes, my lord, they are still.
Hmm?
Yes, my lord, because there is a stay order, my lord, accordingly, they are still operating.
On the last occasion, your lordship,
My rejoinder was filed on 16th of May.
we have filed in our affidavit, your lordship,
But the stay order has not been extended.
But they are still operating, ma'am.
they are still operating, and that causes havoc, your lordship, towards, because it is within the premises of school campus. And the ongoing, your lordship, that carried out by petitioners, shops where, your lordship, one is a scooter garage, another is tires, and other is harmonium, tabla, and pawn shop is also there, and mechanical shop, which causes, your lordship, disturbances towards the school premises, your lordship. So we have already stated, your lordship, that disturbance causes, first, your lordship, noise pollution is already been caused, your lordship, and that creates a disturbance towards the school.
What is your status as a tenant?
Yes, my lord.
Tenant from whom?
From the school managing authority prior to its provincialization.
Let us see. Where?
That is it is annexed, my lord.
Huh?
The writ petition, page 16. It's a type copy. The original at page 18. It was executed with the father of the petitioner number 1. Yes, the father is on.
Other has already been.
But
your
it has been
lordship,
time to
this
time
is,
renewed,
your
my lord.
lordship.
Yes, where is the renewal?
And on behalf of the agreement is made, Nurul Islam, MA President, Madrasa High School, School
We'll
Manager.
have this immediately on the reopening for disposal.
Lord.
Admission hearing stage.
Lord. Along with that, my lord, my rejoinder may be brought on record, my lord. That it was filed on 16th of May.
T. Chakraborty.
Worship.
Sri T. Chakraborty, learned counsel for the petitioner, submits that a rejoinder affidavit has been filed on 16/5/2025,
Lord.
which however has not been tagged with the records. Para. Also heard Ms. P. Das, learned, you appear for whom?
Secondary education.
Learned Standing Counsel, Secondary Education Department, who has expressed urgency. Para. Considering the above, as well as the aspect that this writ petition is pending since the year 2016, list for admission hearing on 15th of July, along with the rejoinder affidavit.
Lord.
Immediately on the reopening, madam.
Lord.
15th, Tuesday.
Oblige.
Yes.
Deeply open.
Item 19.
Yes. None appears for the petitioners on call, whereas Sri A. Ganguly, learned counsel for the respondent bank, is present. Para. On the last occasion, that is 18/6/2025, the following order was passed. Para. It clearly appears that the petitioners are not interested to prosecute this case. Para. Accordingly, the writ petition is dismissed for want of prosecution. Is there an interim order? No interim.
There was, it was not extended.
Interim order, if
There
any.
is IA also that way.
Interim order, if any, stands vacated. IA to separately go in view of the dismissal of the writ petition. Today, the IA stands dismissed.
My lord, this matter relates to payment of compensation of land which was taken over by erstwhile AACB, now APTCL, my lord, without any authority of law, my lord. In the year 1963, my lord, a plot of land of 3 kathas, 14 lestas, my lord, of the garden land. My lord, that whole land was taken over by the Air Force Station.
CCC is there. Did you see? Oh, you are there. Okay.
Their affidavit is very important. So because the ACP, my lord, as it was back then, was instructed or rather directed to set up premise a substation at the Digaru to cater to the electricity requirements of the Digaru Airport Station. And there the substation till date is still operating. It was at the
The substation was established on the request on to felicitate them, the Digaru
yes.
Air Force.
Yes.
So if it is required by the, so your stand, the payment will come from the airport, the central government.
If my lord,
there is no process of taking over the land, my lord. It was just taken over without any authority of law until
No acquisition proceeding.
no requisition nor
No acquisition.
no acquisition, neither requisition. Until that, no compensation has also been paid. And the APTCL has categorically admitted, my lord.
Yes, your file your affidavit. Heard Sri M. Khatuniar, learned counsel for the petitioner. Also heard Sri B. Chaudhary, learned counsel appearing for the APDCL. Para. Do affidavits have been exchanged between the petitioner and the APDCL, comma? The affidavit by the central government is yet to be filed. Full stop. By the from the dispute involved, the stand of the central government would be important. Full stop. Miss, what is your name? B. Rabha, learned counsel appearing on instruction of Sri or Miss Yegan. Praise for and is granted 3 weeks further time to file affidavit in opposition. File it. Have you got the instructions or not? Yeah, the instructions is pending since 2022. 3 weeks. Okay. Next. 21. Yes, what is this, Mr. Chaudhary?
As per the instruction that my learned friend has obtained, probably the grievance has been addressed by the respondent, so they are not allotted certain space. Has been allotted. Although I have no specific instruction.
Heard Sri S.P. Chaudhary, learned counsel for the petitioners. Also heard Sri State Counsel, Mr. Bijet, State Counsel, Sri Bijet Talukdar, Mr. Bijet Talukdar, learned addition senior law advocate, as well as Sri Aadhar, learned counsel for respondent number 5. Para. Do Sri Dhar, the learned counsel, has submitted that during the pendency of this writ petition, a resolution was adopted to accommodate the vendors, which includes the petitioners. Para. Sri Chaudhary, learned counsel for the petitioners, however, submits that the clients are not in touch and he has not been equipped with the latest instructions. Para, be that as it may, in view of the categorical submission which has been recorded above, and even on the earlier occasion, comma, this court is of the opinion that there may not be any live cause of action which requires further adjudication. Para, the writ petition is accordingly closed. Yes, next.
With the liberty lordship, if any issue remains, then
It is needless to state that for any existing grievance, for any further grievance, the petitioners would be at liberty to approach the appropriate forum.
22.
Lordship, in this case, last day the revenue department has got type to file affidavit in opposition. Only the respondent number 4 has.
Who is for? Who is for?
Circle office.
Okay, Revenue Department, Madam Monta.
Circle officer, I am appearing.
No, your revenue. Is it required? Revenues.
one affidavit is filed on behalf of the circle officer.
That we have seen.
Correct.
No, is any other affidavit required? Hmm?
Your Lordship, this matter relates to, Your Lordship, in this case, the petitioner interest of the petitioners was the owner of about 84 bighas of land. But during resettlement, Your Lordship, it was divided into 4 new pattas, and during that period, about 25 bighas were went missing, Your Lord. This respondent number 4 has filed this affidavit, but nothing has been mentioned in that.
You were originally the owners of how many, what is the area?
Your Lordship, KP patta number
What is the area?
302, 84 bigha, 4 katta.
84 bighas.
Your Lordship.
You were the registered owner,
Yes, pattada.
Patara. Then what happened? There was a resettlement.
Yes, Your Lord.
Then some areas has not
25
been
bighas
mentioned.
were missed.
What is your stand, Mr. Sharma?
Our stand, it is reflected in paragraph 4 of our affidavit.
What have you stated?
Paragraph 4 of the affidavit filed by the respondent number 4, wherein it is specifically mentioned that the settlement officer reveals that the name of the Horikanto Roy Medi was in KP Patra number 155 of village 1 of Chapurigog under Beltola Musa was inserted during the land settlement operation from 1984 to 2009. Similarly, the name of Horikanto Roy Medi and Koran Lekhar was in KP Patra number 156 of village number 1 of Chapurigog under Beltola Musa was inserted during the land settlement operation that earlier at the same.
Yes.
Therefore, the department doesn't have any record to show on what basis these names of the purchasers were included in the land records at the time of last settlement operation. And also doesn't have any power or authority for correction of the land records, which was already done in the last settlement operation. So these 2 persons, Lord. Whether under such circumstances, Lordship, under these disputed questions.
I think this matter, this court will not take it up. Go before some other bench.
Lord.
Respondent number 5. Have you seen respondent number 5?
Lord.
List before any other bench.
Lord.
Mail. Lord, 23, Lord, respondent number 5 has filed affidavit in opposition, Lord. We have to reply.
When was the affidavit in opposition filed?
Yes, it was filed a long
October
back, Lord.
2024.
Yes,
What are you doing till all this time? 7 months have passed. 8
Lord,
months.
The learned advocate who, Lord,
On the prayer of Sri M.M. on the learned counsel for the petitioners submits that rejoinder affidavit would be filed to the affidavit in opposition of the respondent number 5, para. List after 3 weeks to enable filing of such rejoinder affidavit.
Obliged.
Item 24.
Plus, this may be checked with 391023. That is, my lord, we have filed a common affidavit wherein there were no eviction in revenue area.
Sri D. Gogoi, learned standing counsel Forest, has submitted that there is a connected writ petition WPC 3903.
3910.
3910 of
23, madam.
23, in which affidavit in opposition has been filed. And he prays for connecting this writ petition with the said writ petition, para. It is, accordingly, it is directed to list this case along with WPC so and so.
Hold it.
28 and 29.
Lordship, in this matter, a demarcation had been directed by this honorable court on 28/2/25.
Court has directed demarcation.
This honorable.
Lordship, may I? Lordship, there are two petitions relating to a marble factory in Dima Hassan. 28, cement factory. 28 is a petition by alleged landholder.
There cannot be a marble factory in Dima.
Cement factory, cement factory.
It has to be Rajasthan.
Yes, yes, Your Lordship, cement factory.
We can't go to
I'm
Rajasthan
ready to
now.
yes,
It's
Your Lordship.
very hot.
So what is the development in this case? The mining agreement has been cancelled. So we are challenging that. I appear for the company, Mahabal Cement. My writ petition is item 29. So it relates to the same cement factory, and the mining lease itself, the raw material has been, mining agreement has been cancelled. So Lordship, may adjourn this matter. We'll see what happens in that writ petition. Subject to that.
And who are you?
Lordship.
Yes, who are you?
Lordship, I'm the landowner.
Landowner.
Yes,
Your grievance is what?
Lordship, the land has been allotted to the company without taking our prior consent and without any compensation. No procedure has been followed, Lordship. There is no demarcation also. It is an unsurveyed land, but a non-cadastral area.
You are the owner of the land.
Yes, Lordship.
That has been.
Owner, Lordship, we have been allotted the land by the council, Lordship. We pay house tax, Lordship.
And now it has been allotted to them.
Yes, Lord.
Without following any procedure.
Yes, Lord.
Lordship, the prayer is.
When was it done?
Lordship, the allotment was in 2024, Lordship.
And when did you start your company, madam?
Lordship, the company is old. Lordship, we started our work, as in our work is from, we got possession in 15/10/24.
That means from 24 you are.
Yes, October 24.
You are operating.
Yes, yes. Lordship, that
How did you get the land?
Lordship, by way of a tender, Belize. There was a tender. There was a tender with AMDC for limestone quarry.
No, that is so far as
What is that? And then this Dismissal Autonomous Council by way of a lease.
Where is the lease?
Lordship, the lease is.
In your petition?
Yes, Your Lordship. The first
337.
lease is page 46. Page 46 of writ petition 337.
Yes.
That is, Lordship, with reference to subject cited above, I am directed to inform you that the land measuring 2000 bighas along the Garampani Lanka Road between 26 and 29 Umrangsau Dima Hassan, which was earlier allotted for establishment of industrial estate by so-and-so, is hereby re-allotted to you for setting up the cement plant in Umrangsau. And Lordship, may kindly take a look at the prayer. This is the other writ petition. Writ petition number 337, writ petition number 467.
What is that?
The prayer is a clarification. They don't know. They don't know if their land belongs. The allotted land. Lordship may have page 29 of writ petition number 467.
29.
467.
20.
467.
Yes, 29.
Page 29, the second prayer.
Yes.
Lordship has Roman 2, page 29.
Yes.
Direct respondent number 2 to 6, which are the authorities, to provide clear and accurate survey map and documentation regarding the boundaries of the land allotted to respondent number 7, that is the Mahabal Cement, and to clarify whether any part of the petitioner's land is included in the allotment. So they are not sure. Their grievance is, we don't know, please let us know. And Lordship, at this point of time, only demarcation is happening of this area.
Now what can be done? What do you suggest?
At the moment, Lordship, everything is on hold because of the rains, and now the very mining lease has been cancelled. So this is all consequent to that. The Lordship may keep it after 2 weeks. Let's see what happens in that writ petition.
Who's in possession of this land?
We have.
Possession has been taken by the company, Lordship. That
And
area is a
Mining
farmland.
lease is cancelled.
Not the lease. The mining
permit?
agreement, the mining agreement
With AMDC.
with AMDC, yes, Your Lordship.
Lordship,
And
there's
we
a
filed a
key
writ
clause.
petition, it'll come anytime this week.
AMDC has appeared.
It's not a, huh? No, Lordship,
AMDC has appeared.
no, if we filed it, it's not come up yet. It's going to most likely come up on
Oh, you have
Friday.
filed a fresh writ petition?
Yes.
But why is this writ petition filed by you? The
This
existing
writ
one?
petition, Lordship, we got possession in October 24. When we got possession, there were kind of disturbances. Local people came and didn't let us do any work. So we filed a writ petition taking
Okay, we'll
protection.
do one thing. We'll have the third case also tagged along with this.
Yes.
But Lordship, that area, the mining lease that has been cancelled, that is in a different village. It is not connected to this property. This is where they're going to set up the cement plant. But the mining is going to be in a different place.
That is right. But the point is, by submission,
Yes,
the
yes.
mining,
Now what has-
this goes to.
Now, what has got the mining lease got to do with your establishment of cement factory?
Because that's the raw material for the
No.
cement factory.
But that you can get the raw material from somewhere else also. That's up to you.
Yes, there is provision.
There may be a
made.
connection, there may not be a connection.
No, Lordship, only thing is, if that goes, we don't know whether how much interested, I don't have instructions so far as to whether interested in the lease without the limestone quarry. So Lordship may keep it after 2 weeks. We'll see what happens in that and then.
What is your name?
AI Qatar.
Heard Sri AI Qatar Learned Counsel for the petitioner in item so and so, filable. As well as Ms. G. Goswami, Learned Counsel for the petitioner in so and so. Ms. Goswami, the Learned Counsel has submitted that so far as the mining lease is concerned, mining agreement is concerned, the same has been cancelled, which cancelled, and a fresh writ petition has been filed by her clients, which is yet to be listed.
Yes, file yet to be listed.
Which is yet to be listed. Para. In view of the aforesaid development, she submits that instructions will be required regarding the present writ petition instituted by her client. Para. In view of the above, list these two cases on 23rd of July.
Lordship, in the meantime, the demarcation may be completed. Because since it's rainy season and our farms have been taken into possession, Lordship, we are unable to farm.
It is going on. It's subject to rain.
The pendency shall not be a bar for proceeding and completing the demarcation process.
Applied.
Same order, huh? Same, no, one order. Order. Okay. Yes.
Item 39.
But this matter can be disposed of. Actually, the requisition was filed apprehending that my lord they will be evicted from the land because of my lord that advantage Assam 2 and my lord there was demarcation going out without any notification. Now affidavit has been filed that my lord they are not going to acquire the land. Therefore, my lord, there is no live issue as such. If my lord they want to later on acquire the land for any purpose under the law, my lord.
Due procedure will be followed, man. Affidavit is very
Yes,
clear.
Mr. Das for.
ASIDC.
Okay.
ASIDC, in fact, my lord, identified the land,
Okay.
and thereafter, my lord, circle officer went and measured the land.
Okay. Third, Sri M.K. Chaudhary, Learned Senior Counsel, assisted by who? M.M. Kashyap for the petitioner. Petitioner, huh? Also heard Sri N. Das, Learned State Council.
2-4.
As well as Sri S. Das, Learned Standing Council, ASIDC.
Yes, that's what I'm saying,
AID.
AIDC, para. In view of the in view of the stand by the respondent number 4 in the affidavit in opposition filed on 29/5/2025 and as agreed to by the Learned Counsel for the parties, this writ petition is taken up for disposal at the admission stage. Please have your seat. the grievance of the petitioner and the members of the committee was with regard to the proposed move to set up a new industrial estate within bracket phase 1 in certain land which has been identified by the AIDC. Full stop. The lands and the petitioner project that the land in question is owned and possessed by the members as partners or riots. Full stop. However, comma, from the affidavit in opposition filed by the respondent number 4 on 29/5/2025, comma, it has been clarified that though certain identification process had taken place, comma, there is no move to acquire the land in question. Full stop.
The acquisition estimate has been prepared.
And only certain estimates have been prepared. Para. For ready reference, the averments made in paragraph 9 of the said affidavit in opposition are extracted herein below. Page 40, paragraph 9. Wrong. Para. 3. Chaudhary, the London Senior Counsel for the petitioner accordingly submits that in view of such stand of the respondent, comma, the writ petition may be closed, however, with a direction that in case any land is required, comma, the same has to be either acquired or required by strictly following the prescription of law. Para. In view of the aforesaid facts and circumstances, comma, the writ petition, this court is of the opinion that there is no live cause of action to be adjudicated. Full stop. Adjudicated, and accordingly the writ petition is closed. Full stop. It is, however, clarified that any process for acquiring the land has to be done by strictly following the prescription of law.
Kindly object.
Item 42 to 44.
But in this case, already all the three petitioners have already been evicted from their land. That encroachment of land over the TB hospital, tag number 97.
Okay, now
We have received instruction, we'll file our affidavit.
any you want to proceed with this case?
Yes, okay, because some compensation is to be, because our houses were all bulldozed.
Houses over what? Patta land?
No, government land.
What right do you have?
We were
You were encroachers.
residing there for last 33 years.
Encroachers.
Encroachers, admitted encroachers.
You took the benefit of 32 years.
Yes.
Free of cost. And you want compensation. What is this kind of a principle?
Or alternative arrangement plot.
What alternative arrangement? What right did you have?
We are a landless plot.
When there are many landless persons. Millions of landless persons. You are occupying government land without paying any nothing as encroachers, and you want compensation. Under what principle?
On humanitarian consideration.
Humanitarian consideration is up to the state, not for the court. State can give you.
That part is not there in their affidavit prayer for compensation.
Third 3, Aadhar, learned counsel for the petitioner. Para. Mr. Barua, for whom?
I am for respondent number 2, 3, and 4 in all the cases.
2, 3, and 4 state respondents?
Yes.
You would file affidavit? No, I think he'll file.
Lord.
Also heard Miss G. Hazarika. learned Standing Council Revenue, and Sri S.R. Barua, learned State Council. Para. Sri Barua has informed that the eviction proceeding has already been carried out. And he prays for time to file affidavit in opposition. Para. Let these cases be listed after 4 weeks
Got
to enable filing of affidavit in opposition.
Got obliged.
Right. কিমান থাকিল? মোশন কোনটো আছে?
May please, Your Lord.
Yes, please.
My lord, here is the case, this is the second round of litigation. The petitioners, my lord, they are the elected ward commissioners, my lord, of Lanka Municipal Board. And the private respondents, my lord, from 5 to 10.
How many of you are there?
My lord, we are, petitioners are 5, my lord.
5 petitioners.
Yes, my lord.
You are elected members of?
Yes, Lanka Municipal Board, my lord. And the private respondents, 5 to, my lord, 10 also, they are, my lord, the elected members. Now, what has happened, my lord? On the earlier occasion, the respondents 5 to 10, they issued a requisition on 2/6/25 for holding a special meeting of no confidence. My lord. Now, that
Against whom?
Against the, my lord, petitioner 1 and 2. 1 is the chairman, my lord, and 2 is the vice chairman.
Yes.
Now, my lord, that requisition was challenged inter alia. Amongst other grounds, there were other grounds also saying that it is validity of 43 because the requisition has to be addressed to the chairman, my lord, giving him an opportunity to hold the meeting. And if within 20 days, in terms of the mandate, if he doesn't hold, my lord, then they can initiate the proceeding. So the argument was that, my lord, bypassing 43(2), they had issued the requisition. And having been satisfied, this honorable court, without going into other grounds, my lord, on this ground, interim order was passed. That order your lordship will find at page, my lord, 47, which starts at 47, my lord. And the relevant part, my lord, is at page 51.
5-1.
5-1, my lord. And I may draw your lordship's attention from 50, my lord. Paragraph 8. Section 43(2). Your lordship has got it, my lord. Mandates that a special meeting can be convened by the chairman or in his absence, the vice chairman, including a requisition of not less than 3 of the commissioner. However, in terms of subsection 3 of section 43, in the event of chairman or vice chairman fails to call such special meeting within 20 days from the date of any requisition in terms of subsection 2 of 43, a meeting may be called by the person who signed the requisition. In this specific case of the petitioners and pleaded at para 9, that no requisition under 43(2) of the Assam Municipal Act 56 was given, and therefore the impugn notice is sustainable. And thereafter, my lord, the impugn notice was stayed and making it returnable on 1/8/25. Now, your lordship will see, curiously enough, this is an order of 12. And thereafter, my lord, we had taken steps by registered post as well as dusty survey. On the next day itself, my lord, in a hot haste, the, my lord, requisitionist, they had withdrawn the earlier requisition at page 53. It is, my lord, in fact, what they say, they are not pursuing the same. Page 53, Annexure 7, it is addressed to the chairman, that is the petitioner number 1, and thereafter, my lord, they write as follows. We, the undersigned elected ward commissioners of Lanka Municipal Board, do hereby tender you our no confidence against both of you on the following grounds. Then, my lord, 1, 2, 3, 4 are the grounds. Thereafter, your lordship will come to the next following paragraph. In fact, we sent a notice of requisition, notice dated 2/6/25, to the executive officer and deputy commissioner, which were suffering from procedural defect, for which we are not pursuing the same. So, meaning thereby, they are not pursuing, my lord, the earlier 2/6 notice. And now, my lord, they say, they hereby requested to convene a special meeting to discuss and decide the no confidence motion for removal of the chairman and vice chairman of the board within the statutory period, and for which act of kindness we understand we have been getting.
Yes.
My lord, my respectful submission is, first submission is, my lord, this is, my lord, a notice which is amounting to overreach, my lord, the honorable court. Because they are aware
that an order is passed by this honorable court amongst others. My lord, 43, apart from 43, there are other grounds which are, my lord, in session before this court. Even if, my lord, the earlier notice, my lord, requisition is withdrawn, if 43 goes, 43-2 goes, other ground remains. So therefore, my lord, this particular
No, if the requisition, the request is withdrawn, where is the scope of the other grounds?
There are other grounds, my lord.
There may be, but they are withdrawing the requisition earlier.
Yes.
Can you force them to
No,
continue
I am
with,
not forcing, my lord.
with a flawed? No, they have become wiser. They have withdrawn.
They have withdrawn
given
the
under-
earlier, they have withdrawn the earlier.
No, that is not a ground that the earlier case is pending. If you have fresh grounds, you.
I have fresh ground. Because this 13-6, my lord, is also under challenge in the present case, my lord. 13-6 is challenge.
That is the challenge. Challenge on what grounds?
Yes, I'm coming to that, my lord. Firstly, my lord, what has happened? The municipal board is comprised of the elected members as well as ex officio members.
How can you preempt them from not holding a meeting?
No, my lord. Your lordship will kindly allow me to submit, my lord. What has happened? My lord, prior to delimitation exercise of 23, my lord, 3 ex officio members, there were 2 MLAs and 1 MP. My lord, they were also part of the board. So the composition was 14 members. I have stated, my lord. Now, subsequent to the delimitation exercise of 23, now the composition has changed. 1 MLA is excluded. The MLA of Hojai is no more, my lord, the ex officio member. And the MP, my lord, representing, my lord, the constituency of, my lord, Noagaon is no more the MP because presently, my lord, the Kaziranga constituency, it comprises, my lord, the municipal area. And in terms of the provisions of the Act, my lord, the MPs and MLA who represent those areas, my lord, are the ex officio members. Now, pursuant to the delimitation, the composition has changed. 14, my lord, from 14, it has reduced, my lord, to 13. Now, in terms of section 11, my lord, the state government has to issue a notification that the present board is comprised of such and such member. Because in terms of, my lord, the provisions of the Act, the, my lord, motion has to be carried through. I take your lordship's, my lord, to the relevant provisions, my lord.
Municipal. Yes.
Firstly, your lordship will come to 11. (11.1). Yes. The number of commissioners of each municipal board shall be such as the state government by notification determined in this behalf. Then your lordship will come to 3A. The members of the House of the People and the Legislative Assembly of the State of Assam representing the constituencies which comprise fully or partly the municipal area shall be the ex officio members of the board. Now, there is a coordinate-based judgment, my lord, reported in 2015 to GLR 808. It says the ex officio members have the voting rights. Now, the, my lord, relating provision of removal is, my lord, 28.
Yes, please.
28, my lord, 28.2.
Yes.
28.2 says, an elected chairman or vice chairman may be removed from his office by resolution of the board in favor of which not less than half of the whole number of commissioners which shall have given their votes at a special meeting specially convened for the purpose. Now, your lordship will kindly take note of. This is amended. This is amended. I'll come to that. I have annexed the notification. Now, your lordship will see 28.2 speaks about whole number of commissioners. And this will include, my lord, the ex officio members also. Now, 28.2, my lord, has been amended by way of a notification. Page 55, my lord. 55, it is of, my lord, 19th May 2012, it has been amended. And section 2 thereof, my lord, page 55, section 2, in the Principal Act, in section 28, in subsection 2 for the wards not less than half, the words more than half shall be substituted.
Yes.
Now your lordship will kindly see to determine what will be the, my lord, more than half. Firstly, one has to know the composition, my lord. The state government has to, my lord, notify that presently there are 13 members, including ex officio members, my lord. Now, in absence of the notification, my lord, who will attend
Where
the
is the requirement of notification?
11.1, my lord.
No, ex officio, that is, where is the requirement of further notification?
No. My lord, your lordship will kindly see, now since the composition has changed, my lord, who will attend the meeting? Because one MLA is excluded. A new MP has come, and in terms of section 25, the MP has to take vote. If your lordship comes to 25, my lord. Taking of oath.
Yes. Yes.
Every person who is elected to be commissioner of the board or who becomes commissioner of board by virtue of office, that is the ex officio member,
Yes.
shall, before taking his seat at a meeting of the board, first attended, make an oath or affirmation of his allegiance to the Union of India in the following form. Now, the new MP, my lord, in terms of 25, has to take an oath before participating, my lord, in the meeting, my lord. So, unless, my lord, these requirements are followed.
Have you stated that he has not taken oath?
Yes, I have stated, my lord.
Where?
This is my entire case, my lord. Para 19, my lord. Page 20, para 19.
Please read.
It is stated that section 25 of the Act of 1956, as extracted herein above, prescribes that every person who is elected to be commissioner of the board or who becomes commissioner of the board by virtue of office shall, before taking his seat at a meeting of the board, first take an oath or affirmation of his allegiance to the Union of
general
India.
statement. Where is the statement that the MP has not taken oath? And even if such statement is there, what prevents them from having the MP taking an oath before the meeting?
Notification is bad. Well, the notification would require. my
That
lord.
is up to the state government.
No, without the notification.
No, up to the state, how do you do preempt? Why are you shy of facing the procedure of law?
My lord, my respectful submission.
You cannot force yourself to occupy a seat if the majority has lost confidence.
That is what I am ready to take.
Face it.
My lord, I am ready to face it. My lord.
Earlier, you had a very good ground.
Yes.
In the earlier petition, and rightly the court has passed an interim order. They have become wiser. They have withdrawn the earlier, given a requisition to you. You decide. You hold the meeting.
My lord, my respectful submission is the procedure is prescribed under the Act. My lord, who will sit, who will vote, my lord.
Yes.
Now, pursuant to the delimitation.
That we cannot contemplate. Who will vote, who will sit now on the strength, on the basis of a requisition notice.
My lord will then, my lord.
That is at a very nascent stage. We do not even know what procedure is going to be adopted.
My lord will kindly see. My lord,
in the requisition, if you can show anything wrong, illegality in the notification of 13/6/2025,
yes.
We otherwise we cannot.
My lord,
it cannot be on the basis of contemplation, stipulation, this will happen, that will happen.
No, my lord, these are on basis on records, my lord.
Records, but these are going to happen in the future.
No, my lord.
You show this, that what is the illegality in issuing a notice of 13/6 by members who have expressed no confidence upon you.
Issuance, my lord, of the requisition,
yes,
my lord, cannot be precluded. They can issue the requisition, my lord. What I am on, my lord, on the basis of such a requisition, my lord. Now it cannot proceed in view of, my lord, this.
Oh my God. No, sorry. That will be too far-fetched. Sorry.
My lord, can it be this way? My lord, there is a power under 296 of the respondent. If I take your lordships, my lord, to 296.
Yes.
The state government or deputy commissioner or the additional deputy commissioner, my lord, they have the power, my lord, to debar the board, my lord, from proceeding further.
Why? Under what condition 296 will be applicable? Have you seen?
Yes.
Yes.
My lord, there is a my lord, one requirement or the execution of the resolution or order.
There has been many litigation on 296. Under what provision 296 cannot be exercised just on the whims and fancies.
Your lordship will kindly
They are
say,
trying
no,
to exercise a democratic right. Let them exercise. If you are confident of your strength, you pass.
your lordship will kindly take up tomorrow.
No, sorry. Heard.
Well, 296, your lordship will see if it is in excess of powers conferred by law.
Yes. No. Heard. Yes, Your Honor, caveat. Heard. Sri R.P. Sharma, Learned Senior Counsel, assisted by M.N. Soikar, Learned Counsel for the caveators, who has lodged this caveat in respect of a notice dated 13/6/2025. Para, the caveators would be heard in the event this court proposes to pass an interim order. Caveat is discharged. In the writ petition, you write, heard Sri S.K. Talukdar, Learned Counsel for the petitioners. Full stop. As per the facts projected, the petitioners, who are 5 in numbers, are the elected members of the Lanka Municipal Board, and the respondent numbers 5 to 10 are also elected members. The respondent numbers 5 to 10 had issued a requisition on 2/6/2025 for a no confidence, full stop. The said move was, however, the subject matter of challenge in a writ petition instituted by the petitioner registered as WPC 3274 of 2025. Full stop. This court, on being prima facie satisfied of the violation of section 43(2) of the Assam Panchayat Act 1956.
No, Assam Municipal Act.
Sorry, Assam Municipal Act 1956, while issuing notice, had also passed an interim order. Full stop. It is the case of the petitioners that immediately on the next date, the present impugned notice has been issued on 13/6/2025 to the chairperson, who is the petitioner number 1.
Well,
full stop. The learned counsel for the petitioner has submitted that due to the delimitation exercise, there is a change in the constitution of the board, and the number has come down from 14 to 13. Full stop. There is also change in the particular constituency, the MP of which would be a member of the board ex officio.
Right.
And in this regard, notification are yet to be issued.
Under section 11, Mal.
He issued, full stop. He has drawn the attention of this court to section 11, 11, to submit, and has submitted that such submitted the provisions of ex officio members. Full stop. He has also submitted that ex officio members also has the right to vote in such elections. Full stop.
Such meetings,
special meetings. The learned counsel has also drawn the attention of this court to the amendment of section 28(2), as per which presently the requirement is more than half. Full stop. The entire gamut of the argument is that without coming to a definite conclusion as to the number of members who would participate in such meeting, the meeting cannot be allowed to proceed. Para?
My lord, my submission is notification under section 11, my lord, 1 is necessary. And so, my lord, specify the composition, my, that it will be 14, 13 or 14, my
He has also submitted that under section 11 within bracket 1, a notification is necessary. We have already said about notification.
The state government, my lord, will issue a notification in this behalf, determining, my lord, the number of commissioners. 11(1).
11(1). Para.
That notification is not yet issued, my lord.
Last week has done. Necessary. Okay. Per contra, no, per contra, let notice be issued, returnable,
The other one is on 1/8, my lord.
returnable on 1/8, or notice be issued. At this stage, this court has been informed that the earlier writ petition is directed to be listed on 1/8/2025. Let this case, the returnable date of this case is also fixed on 1/8/2025. Para. 3, who will accept notice? 3 H. Sharma, learned additional senior advocate, Assam, accepts notice on behalf of respondents 1, 2, 3, and 4. Whereas 3 Saikya, learned counsel, accepts notice on behalf of respondent numbers 5 to 10. Let extra copies be served upon the learned counsel for the respondents within 2 days. Para. Heard the learned counsel on the interim prayer. Para. The grounds which have been presently urged are more on stipulation as regards the future course of action. Full stop. Such grounds, in the opinion of this court, may not be prima facie grounds for suspending the process which has been sought to be initiated by the order dated 13/6/2025. After all, it is a mandate of law and the democratic right to have a no confidence motion held in accordance with law. Para. In view of the above, this court is not inclined to pass an interim order.
My lord, in the meantime, the state government may issue the notification.
Will not say anything. Why, if they allow issue, if they not issue, maybe you have a case tomorrow.
Hold on a minute.
Can I provide?
My lord, the petition number 1 has expired, but my lord, on October 24, but I could not contact. But in the meantime, they did not also communicate their legal here. So, my lord, and this matter may have infructuous because of the, my lord, it was relating to correction of a record, land record. And in the meantime, no communication has been made. I think that has been done or not, my lord. So, my lord, matter will be taken after vacation.
Now we'll close this.
I shall take instruction.
You have not been able to do, okay. Heard 3S not learned counsel for the petitioners, as well as, full stop. Also heard 3H Sharma learned additional senior advocate Assam, as well as 3MU Mondal learned counsel for the respondent number 4. Para?
4.
The matter relates to correction of land records.
Land record.
Para? The writ petition was instituted in the year 2017, and the orders it reflects that almost before a year, no, more than a year back. No, almost almost a year back, the petition number 1 had passed away. Until now, no steps have been taken for his substitution. Full stop. Even on the last occasion, when this matter was listed on 30/4/2025, time was granted to the learned counsel to take steps. Para? Srinath, the learned counsel has, however, fairly submitted that the clients are not in touch with him.
Yes.
Full stop. Para? In view of the effort situation, it will not be possible. And this court is of the opinion that the petitioners are not interested to pursue this case any further. The petition is accordingly dismissed for want of prosecution.
Deep look.
No, my lord, let me close this infructuous. Otherwise, my lord,
Non-prosecution. Infructuous may not be infructuous, we do not know.
non-prosecution is, my lord, since I am.
No, your presence is not prosecution. Your presence with instruction is prosecution.
Or maybe abated, my lord. Otherwise, maybe abated.
Abated. Will not use abatement. Not prosecution. Yes. Next.
Or maybe closed, my lord. Otherwise, dismissed.
Doesn't matter. Yes. Yes, next.
47.
Mr. Das.
My lord, the last date, my lord, I could not appear before the Lozima court on 17/6/2025, my lord. To take step upon the respondent number 3. So I may be given an opportunity to take step on respondent number 3, my lord. And my lord, as per official report, the step already taken upon respondent number 3 was returned as not found, my lord. But as per page number 78 of my petition, my lord, annexure, the address is given at the bottom of the petition page, my lord.
Okay,
So
you take
in the
steps.
new address, I may be permitted to take step, my lord.
Okay.
Within tomorrow. Yeah.
Do the order dated 17/6/2025 of the learned Lozima Court has reflected that steps for service of notice upon the respondent number 3 has not been taken, comma, Sri P.P. Das, learned counsel for the petitioners, has submitted that he may be allowed to take fresh steps, such steps upon the respondent number 3 by registered post with AD in the corrected address.
Yes, ma'am.
Para?
Yes.
In view of the aforesaid submission, 2 days' time
Yes.
is granted to the learned counsel for the petitioners to take steps for service of notice upon the respondent number 3 in the corrected address. List after 6 weeks for service report.
Yes, my lord. My lord, interim order as per earlier, my lord, on 22/2 of 2021, may kindly be.
Returnable date was a long time back. How can
Yes,
we
my
extend?
lord. Matter was not come up before, lord.
4 weeks. Will not say anything. Okay, interim order.
Yes.
To continue till the next date of listing.
My lord, as per Lozima court's order, my lord, service has been completed.
Service is complete.
Lord.
I have appeared for respondent number 8, my. Earlier I filed for respondent number 9, but he has, my lord, already retired. Now he is running this institute, respondent number 8, my. And 8, 10, 11, my lord, all these schools, my lord, are now in one complex, my. Amalgamated and then upgraded. One man is running. Respondent number 8, my.
Where is the Lozima court's order that service is complete?
My lord, 19/6/25, my lord, there is an order.
19/6.
Lord.
19/6.
Last part, my lord, can.
19/6. There is no 19/6. The last order is 13/6. Last order is 13/6.
Morning, I have said. Morning time.
19/6.
19.
2020?
19/6/2025.
There is no 19/6. The last order is 13/6.
Can I help, my?
48.
Okay, I'm sorry, 49. Our item is 49. 48. He's for 48, my.
Lordship, the matter is infructuous.
Okay. What is your
I'm
name?
for the petition.
What is your name?
MUE Bhuya.
Huh?
I'm appearing on behalf of my senior, Mr. K Bhuya. My name is MUE Bhuya.
MUA.
MUE.
MUE. Heard Sri MUE Bhuya, learned counsel appearing on instruction of Sri K Bhuya, learned counsel for the petitioner. Also heard Sri S. Bora, Learned Standing Council. GMC, para. In this case, notice was issued on 19/2/2021. Full stop. The learned counsel for the petitioner has, however, submitted that by efflux of time, the matter has become infructuous. Para. Writ petition is accordingly dismissed as infructuous. Next.
49.
Sorry, my lord. Nineteen six.
Peruse the order dated 19/6/2025 passed by the learned Lozima Court regarding acceptance of service upon the private respondents. Full stop. The said service is accepted. Para. Yes.
I am for respondent number 8. I have filed vocal number 2 itself, my lord, for respondent number 8. But earlier filed, my lord, for respondent number 9, but 9 already retired.
Return. Sri So Learned Counsel has submitted that though he had entered appearance earlier on behalf of the respondent number 9, he has retired from service, and today he has filed the wakalatnama for respondent number 8. Para. Will you like to file affidavit?
If necessary.
If necessary, what? He prays for and is granted 3 weeks time to file affidavit in opposition.
Public. Otherwise, civil dispute, my lord.
My lord, last occasion, my lord, on 14/2/2022, there was a direction to the respondent number 5 and 4 to file affidavit. They have not filed.
5 and 4 state respondent.
Lot. For 5 and 4.
By such time, the state respondents may also file affidavit.
Public.
Report H. Sharma Likhidi, appearance. Edition Senior Guard. 50.
Yes. I am appearing on behalf of R. Alima Senior Lordship for respondent number 6.
You have filed affidavit?
Yes, sir.
You have filed affidavit? When?
I am appearing on behalf of R. Alima.
No, have you filed affidavit?
No, Lordship. I'll file.
Okay. None appears for the petitioner on call, whereas Sri S. Bora, Learned Standing Council, GMC, and Sri, your name?
M. Boro, Lord.
M.
Boro.
Boro, Learned Council is present on behalf of the respondent number?
6, Lord.
6, as instructed by Sri R. Ali, Learned Council. Also, Sri H. Sharma, Learned State Council is also present. Para. On the prayer made by the Learned Council for the respondents, matter is adjourned by 4 weeks to enable filing of affidavit in opposition.
51.
Wait, please, wait. It's the office of the service is completed, Lord.
Private respondents are there.
It was PMB, Your Lord. PMB, Tinsukia Municipal Board.
Okay. You're appearing?
I'm appearing on behalf of Mr. S. Roy. We have not received any copy for the same.
Copy of what? Writ petition?
Petition, yeah.
The service was made to your client. You should have got the copy.
And also, Your Lordship, the name of Tinsukia Municipality was to reflect on the cause list.
Are you the standing counsel?
No, I'm appearing on behalf of Mr. S.
S.S. Roy?
Yes, he is the standing counsel for.
Oh, there is a standing counsel?
Yes, sir.
Okay.
However, at that point of time, there was no standing.
Okay. Seen the office, seen the order dated 19/6/2025 passed by the Learned Lozima Court. Full stop. Service upon respondent number 4 is held to be complete. Para. In fact, your name?
Mr. David Board. We have David Board.
Sri So-and-so Learned Counsel has appeared on behalf of Sri S.S. Roy, counsel for the Tinsukia Municipal Board.
Respondent
number 4. Who is required to file affidavit? The matter is adjourned by 4 weeks.
Like,
To
can it be
enable-
on 16/6, my lord.
Huh?
16/6, my lord. 16/6 after vacation, your lord.
16/6 or 16/5, 7.
16/7, your lord.
By 4 weeks, by 4 weeks to enable the respondents to file affidavit in opposition.
Intend to continue, your lord.
The name of standing counsel TMC be reflected in the cause list.
Yes.
Interim order passed earlier to continue till the next date of listing.
Deeply obliged.
Now নামটো লিখিলো MZ Boranik বুলি কলো।
May I take your lordship's indulgence in item number 18? In this matter, today I file impleadment petition on behalf of some of the interested parties. And my learned friend, who appears to be petitioner, he mentioned the matter that it should be taken up on 21st of July.
Yes.
So could it be on another date or 23rd July? So Lord, 25th.
It has already been signed, we'll see. কোথাও নম্বৰটো কোনে মাৰিছিল বাৰু মেনশ্যন কৰা হৈছে না বিনয়টো গুচি গ'ল সাইন হৈ গ'ল It's already been uploaded. We will make a mention on 21st if you have a difficulty with it.
All right.